Testing, testing.
Not what the law says. If you guys can all argue about the legal parts of it, we don't
I
have no
haven't
objection to you getting it. I just assume like, so maybe
What if you don't agree
because we were planning to do our first community meeting.
Testing, testing.
and all that? The reality is,
I just don't know how it's
the
possible
idea
to do so
makes
without.
sense. Like the first one, feedback.
Just because there will be the regulation.
And let me turn to staff, I guess, to kick us off. So.
Good morning, Mr. Chair and Commissioners. I am Philip Vanderhayden. I'm the Net Metering Working Group facilitator / leader. What we're going to do today, I think, depends a little bit on what the Commission's preferences are for the presentation. We've got for you chapters 1 through 5 of 2062 and a portion of chapter of 2050 that we need to make some changes to. Most of these changes are at compliance with HB 908, which made the community solar program permanent. It's my understanding that, and we've got a fair amount of consensus for this, and we spent 3 hours last Thursday getting a few more items of consensus that I hope have maintained themselves to today. I have a document up on the screen, which is what we filed. It's color-coded, and I'll explain that in this, when we get ready to go through it. But it's my understanding that sort of joint panels. I think maybe the utility folks, and then jointly and individually some of the solar folks, and I believe OPC may have a desire to express some opening statements to you. And I had inquired as to that, but we don't quite know if that's something you would like to do at this point. But I think it might be helpful to sort of align the discussion to there's numerous points throughout the document that are non-consensus, but they sort of link together. So I think I would recommend allowing those parties to make those statements.
So we'll start with opening statements of a sort from the various entities. My only request is that we make the statements concise to the extent we can. So we'll start with the utilities, and then we'll move to the solar folks, and then we'll end up with OPC and then staff. So, Mr. Michelle, go right ahead.
Good morning, Commissioners. Joel Michelle on behalf of the Exelon Utilities. And what I think might be most efficient, I think a lot of the non-consensus items that remain go to the question of whether or not the community solar queue that's currently managed by the utilities should remain as part of the permanent program. And so my thought is that if we could tackle that question, depending on what the commission decides on that question, we could probably eliminate the need for discussion on particular line-by-line edits. So I'll focus my comments on that question.
Okay.
So as I mentioned, this question of whether or not the community solar queue that's currently managed by utilities should remain is something that came up most recently, if you might remember, in a matter that the commission heard involving Ten Oaks LLC. And just by way of brief background, Ten Oaks was managing a project that BGE had spent several years working with them to get up and running. And because of certain deadlines that were applicable to the pilot program and restrictions in terms of extensions, Ten Oaks had to file an emergency request for an extension of the operational deadline. And Mr. Bugelman represented, his firm represented Ten Oaks in that proceeding. And I mentioned before the commission during that hearing that I thought that hearing was essentially a waste of the commission's time, because if the community solar queue that the utilities today have to maintain did not exist, the commission would never hear such a request, because that was a project that BGE agreed was viable and should get the extension. But because of the current provisions in COMAR and the current deadlines that exist within COMAR, the Ten Oaks had to make that request, and the commission had to hear it. The community solar queue that the utilities have to maintain is simply inefficient, right? To help make that point, consider this fact. Today, a developer has to essentially make 3 applications before they can get a project up and running. First, that developer would have to submit an application to the commission. The commission approved that project and provided an identification number for that project. The developer would then have to apply to the utility for a position in the community solar queue maintained by the utility. Now, the community solar queue that the utilities are maintaining did have a purpose under the pilot program. And that's because the pilot program had certain capacity limits. And there were 4 different categories, and each category had certain limits. And so the utilities were asked to maintain that queue to keep track of the capacity limits and indicate to developers if the capacity limit was reached that, you can't be granted capacity in this particular category. The permanent program has gotten rid of those capacity limits. And so the question that I would ask the commission to consider is, what are these developers getting in line for? because there's no capacity limits. There's no maintaining of a queue for the purpose of determining, which projects get capacity in the permanent program. And then on the other hand, we have the third application process, which is the application into the utilities interconnection queue. That is the queue that is most meaningful now, and it would allow the utilities to have just one process for interconnection for all types of projects. We see no reason why these community solar projects should be unique and have a separate process in and of itself. We don't do that for net metering. We don't do that for rooftop solar. We see no reason why that should be done for these community solar projects in the permanent program. Now, some of the developers represented through CCSA and by Mr. Bugelman's firm suggest that the community solar queue maintained by the utilities serves the purpose of creating a safeguard. I guess the irony in that is it's almost as if the developers are saying they don't trust each other. That, there is a concern that certain developers will try to take up, hosting capacity without any intention of actually going forward and moving projects along. Well, frankly, my response to that is those developers should get their act together, right? They should not do that practice. There is no reason to create further inefficiencies to provide that safeguard. And specifically, what CCSA and others have said provides the safeguard is that part of the application process to the utilities, the developer would have to submit proof of site control and evidence that they have either applied or obtained certain permits that are required. Well, if they do feel strongly about that those two requirements can be incorporated into the utilities interconnection queue. All right, we can think of other ways to incorporate those requirements, but it simply doesn't necessitate having a application process maintained by the utilities when there is nothing that these developers are in line for in terms of those old capacity limitations. And so for those reasons, the utilities have asked the commission to do away with those requirements in COMAR that requires the utilities to maintain a community solar specific queue.
So, when you started, you mentioned you were speaking on behalf of the Exelon utilities. I take it these thoughts encompass BG&E and the PHI companies, correct?
Correct.
Okay.
And I believe, I don't know if PE...
Well, actually, I was going to move
Okay.
to them next, so I just wanted to make sure, I didn't want to skip PEPCO and DPL, So, is there somebody here from Potomac Edison? And if so, if you have similar thoughts or different thoughts on this particular issue, go right ahead.
Sure. Good morning, Chair and Commissioners. Jessica Reba on behalf of Potomac Edison. In the interest of brevity, I'll say that we are aligned with the Exelon utilities on this issue. I believe that we should be looking towards streamlining the regulations so that there's one queue, one process, one set of operational deadlines, and one set of reporting requirements for all projects.
Okay, so let me do that. Is there any clarifying questions? I guess my thought was I'd sort of like to hear from everybody, and then maybe we'll circle back to, okay, so with that, Mr. Bugelmans, and let me know who all amongst the solar community you're speaking for.
Yep.
So.
Thank you, Chair Hoover, Commissioners. David Bugelmans, Regulatory Counsel for Coalition for Community Solar Access. Also joined this morning by Mr. Charlie Kogashal, the Mid-Atlantic Director for CCSA. We are joined this morning by several CCSA members. We have Chaberton, Solar, Turning Point Energy, I believe maybe a few others, Arcadia. They may want to speak on their own behalf, but they are CCSA members. I do want to begin by pointing out that the vast majority of what's before the commission at this point is consensus. And that's largely been to the hard work of the net metering work group through Mr. Vanderhayden's efforts. So, we're very thankful for the point we are at. But there are some very important unresolved issues. And this issue related to maintenance of the current queue and deadline structure, I think, is perhaps the most important. So I'm going to respond to BGE's comments, which unfortunately may not be too brief, but I'll do my best.
Okay, that's fine.
So as counsel for BG indicated, there's several reasons why we believe the current queue structure is appropriate. The first really is the matter of a readiness bar. What BG has proposed is for the commission to revert all these projects effectively to the standard interconnection process. And the way the standard interconnection process works, there is no readiness bar effectively in order to apply. I mean, there is some skin in the game in terms of filling out the application, to get things going, but that's effectively it. The way that the current community solar queue process works is there's 3 required pieces that developers need to provide to get a queue position. It's proof of an application for at least 1 required permit if the project is non-CPCN, or if it's a CPCN level project, you have to provide a completeness determination from the assigned judge. You have to provide proof of site control. So that's a lease, an optional lease, something to show there's an actual interest in the land. And you have to provide a conditional interconnection approval. And in our mind, that readiness bar is very important. BG is correct that the permanent program legislation does direct the commission to remove the queue, the program capacity structures that existed under the current queue. But there still is effectively a queue, and it's interconnection. Our concern is that without this readiness bar, speculative projects that aren't ready to go will hog that capacity. So it is a real issue. It's something that was witnessed with the PJM process with projects applying and then never moving forward and creating issues with that. We think that the current structure, we have 7 years of experience with how it kind of ensures only ready projects or serious projects get a spot. We think it's appropriate to maintain that high quality of projects in the program. The second and also very important reason why we support the queue process from the pilot is actually the associated deadlines for that queue. Under the pilot program, as originally enacted, there were 12-month operational deadlines that could be extended with a deposit to 24 months. And as the commission saw with numerous extension requests, that was extended to 24 and 36 months. So that's where we are now. It is still clear that even 36 months for some projects is aggressive, and it has been difficult, as we've seen with some of these extensions, for projects to meet that deadline. But roughly speaking, we think it is a realistic target to hold these projects to, and to basically make a good faith effort to move things forward to reach operations. Again, going back to the utility position, they've asked the commission to revert to the current interconnection queue process, which is a 12-month deadline. That deadline could be extended in 6-month increments by the utility at the utility's discretion. So to get to the full 36 months that we know these projects, most of these projects need at a minimum about 36 months, we're talking about 4 or 5 extensions, each time having to go to the utility, each time there is a risk it could be denied. So with our experience with how long these projects take to get permitted and up and running, we just think 12 months is woefully short. So it's really just a matter of the current queue process working. Is it absolutely perfect? Are there edge cases where maybe a project can't energize and it needs to come in for an emergency request, as BG indicated? That is possible, but there's edge cases that could happen under standard interconnection rules as well. So I think those types of specific examples aren't a reason to accept the utility's proposal here. Again, this is a very important issue for the industry. We think the current process works well, and we request the commission maintain it.
Okay, so anyone else on behalf of the solar industry who has a either different thought on this or some other aspect that hasn't been covered so far. So,
Yeah, good morning, Chairman, Commissioners. Eric Wallace with the law firm Green Herlocker on behalf of Turning Point. I'm joined by Solar Naini and Caroline Belmont from the company as well. We filed brief comments supporting CCSA's points, and I won't go into detail into those comments. On this issue, Turning Point has supported keeping the process in place and the transparency that the queue provides. One of the issues that we made some progress with staff on last week is kind of coming together a little bit on how to manage the overall 3 gigawatt queue for net metering and community solar, and maintaining a queue of community solar projects while we are moving away from the pilot caps as Council for BGE maintained. Making a decision now to move away from the pilot program queue would give us one less tool to manage the transition towards that overall cap over the next few years. So I think there's another piece there to think about, and there's sort of a big picture to keep in mind as we move forward that I wanted to flag as well. And with that, thank you.
and
Honorable Chair, equally honorable Commission, I want to thank you for having me today. My name's John Lennon Miller. I'm a Howard County resident. I'm representing Chaberton Energy. We are a Montgomery County-based company. We were founded and we're currently still headquartered there. We're the largest community solar developer in the CSEGS program, and we're among the fastest growing companies in Maryland. I want to thank the Commission and your precursors for your leadership and support. I want to highlight a couple of the most important topics of this rulemaking. There's the decommissioning language. I want to thank Mr. Vanderheyden for his ability to communicate with us and collaborate with us on that language. It really underlines the importance of a financeable program for it to be a successful program. And I would just urge us to lean on existing definitions and the legislative intent of HB 908. Also, co-location. I think we need to do this in a way to get it right. Kind of same concept, certainty. Certainty leads to financeability, which leads to a successful program. Regarding some of the comments that were recently made by our colleague here for the utilities, I don't want you guys to confuse the interconnection queue with the program queue. I believe he conflated them both as if they're one queue. They are totally separate processes. I do agree that the capacity buckets are gone, but the interconnection queue and the process is totally separate from getting program capacity. And yes, program capacity under the pilot was slightly different and it was bucketed, but now it's open. But I don't want the two to be looked at as the same thing. A little bit on the interconnection process. So the interconnection process in the pilot program was done purposefully to not fully mirror net metering projects because they are fundamentally different. A net metering project on a roof does not require nearly the same amount of oversight, environmental studies, permitting time frame that a net metering project does. Those projects can be done, you can go from interconnection application to built in 6 months. You simply can't do that for these ground-mounted projects. You have to go through various permitting processes. So I don't want to take the good work that was done in the original rulemaking and throw that away because we're losing a program capacity queue change. The two are not the same. The interconnection process should remain the same as was done previously, as was previously approved by the Commission, and was also in there. I also want to point out that the CPCN process is only making the permitting process more time-consuming, more complicated. So moving to needing a 6-month approval is going to add so much uncertainty to project development. It's really going to lead to a failure of a program, in my opinion, if that uncertainty is in there. And plus, the utilities have said that would mean every 6 months we would be up for a whole new interconnection cost, possibly, which that uncertainty just won't work in the market. That's what one said on the net metering call. They would have the ability to readjust the interconnection costs they gave us, which is too problematic. And I also just want to say, looking at this, the interconnection process was not part of HB 908. We're here to make HB 908 into rules, and there was nothing about changing the interconnection process in there. So I don't think that's something that needs to be discussed. While we should look at the queue when it comes to the program, the community solar program, I don't think this is a proper avenue to look at the queue when it comes to the interconnection process. Thank you.
so anyone else from the industry? Seeing none. So let me turn first to the power plant research program. You may not necessarily have a dog in this fight, but if you got any thoughts on this? Since you're, I guess, tangentially connected to it, feel free to offer them.
Chair Hoover and Commissioner Steve Tolson. Actually, I'm here for the Maryland Energy Administration. I don't believe PPRP did have any comments in this, but on April 22nd, MEA filed very brief comments concurring with staff's proposals, and the only variance was that MEA joined with OPC in requesting that the changes to COMAR 2062-0401A and 0403C be adapted as OPC recommended, so that MEA and OPC could get information directly from the electric companies and subscriber organizations without having to go through the commission. It's just more direct, it's faster, and it saves time and money. But that's all that they had, and MEA does not have a person here today. That person unfortunately was unavailable, so those are my comments, and we have no more to add.
Okay.
If you don't have questions, I would request leave to be able to depart
Sure,
the
sure.
proceeding.
Okay, well, yeah, that's fine, sure. Okay. So, Mr. Osterlander.
Good morning, Mr. Chairman and Commissioners. Jacob Auslander, on behalf of the Maryland Office of People's Counsel. I'm joined today by Mr. Brock Miller, also from OPC. As Mr. Tolson just remarked, one of the main points that OPC has brought forward is this suggestion to amend COMAR to require subscriber organizations and electric companies to provide information and data related to the program to OPC and MEA upon request. Currently, there's a provision that only requires subscriber organizations and electric companies to provide information to the Commission. And as Mr. Tolson said, we think that there's some efficiency and just some logistical benefits from having a mechanism in place whereby OPC and MEA can access the information that they feel is necessary in order to carry out their statutory obligations. Except for that, we generally support staff's position as reflected in their comments, including language that I'm not sure that staff is maintaining this position in this rulemaking. But we do support the suggestion to include language in COMAR governing the definition of decommissioning to determine when a community solar energy generating system is no longer in operation for the purposes of participation in the community solar program.
So, but do you have any thoughts on this?
Not on this particular issue.
Okay, all right, fair enough. Staff.
Good morning, Mr. Chairman, Commissioners. Regarding the issue of the maintenance of the queue, the queue is mentioned in the law. The queue and makes reference specifically to some of the COMAR. So I think when we drafted these, or when these were proposed, these regulations were not intending to make any changes that weren't in compliance with the language of that law. So I think to the extent there isn't a more sort of robust treatment of this as part of the development of this is because making changes to the application process, does not appear to be something that was directly contemplated as part of complying with HB 908. That much being said, I think both parties have made very good points as to should there be a change from the way the pilot program has sort of developed the application process. Staff's comments do not support the sort of the joint utility proposals throughout the areas in the document where they've asked to make those changes. That's not to say that we don't think there are some reasonable points, as noted by Mr. Miller. If they are exposed, if the developer is exposed to changing interconnection costs that would adjust every 6 months, that could potentially be a problem for them. I think on the utility side, there's probably some desire to be able to adjust an interconnection cost, more than once every 2 or 3 years if that changes. So there may be some reasons to take a second look at this, but I don't think we need to make those changes as part of rolling out this program. So we have identified a number of areas where it's not directly mentioned in HB 908, and we will probably want to work on that a little bit further. I wouldn't reject outright what the utilities have proposed, but I think at this point the Commission should should not adopt the language that the utilities have proposed as alternatives in this document in front of you. And I'm not sure if you may want to address.
Well, I would just support Mr. Vanderheyden, but I would also mention that Q, both for the permanent program and for the program we have in place right now, the pilot, is mentioned in the law. It's defined, and it's required to be kept for the pilot program, the queue that's in existence. It's not precluded. Having a queue for the permanent program is certainly not precluded by the new statute.
Okay, so questions for the parties. Commissioner Sussman.
So I guess it seems to me that we have, based on the position of Mr. Bugelmans and others, from your perspective, we have a pretty effective queue process, and to get rid of that and put you into the regular interconnection queue would it sounds like serve to make it more difficult to deploy these projects, which is the last thing we want. So, I mean, it sounds like, where we have a process that seems to be working. I guess, Mr. Michel, is there a resource concern that and so if you can go into a little bit more detail about the kind of resource. I mean, if you were to move these projects into the queue, you'd still have somebody having to go through their documentation. So what is? I mean, I understand sort of from a conceptual basis. Two programs you think is twice as much work as one program. But I'm sort of trying to understand where the challenges for the company are, particularly when you have experience with both queues. You sort of have people that are sort of doing it now.
And Commissioner, that's a great question, and I think that is worth noting. That I understand from the parties who are not tasked with managing the queue, they may think that, look, that has certain values. But from the standpoint of the entities that are tasked with managing the queue and who are often hearing developers complaining about the inefficiencies and the timing of going through and reviewing their applications, we're sharing, based on our experience of managing these queues, that it is inefficient. And to be clear, the suggestion that the Exelon utilities are making and that PE is joining in will not make it more difficult or timely for these projects to get underway. I actually think it's the complete opposite, because we're not suggesting that it's, instead of having these projects go through the community solar queue from the utilities, they instead now have to do something different from what they're doing now and joining the interconnection queue. They have to join the interconnection queue today. What we're suggesting is that you eliminate one of the three applications, into the utility queues, because that queue does not serve a purpose. They're not getting in line for anything. So once that developer goes through the application process to the commission, applies to the utility to get into this community solar queue, they still have to then apply to the interconnection queue. And what we're saying is that get rid of that middle process, where we're having staff process all of those applications, all to do it, processing a third set of applications through the utilities interconnection queue. Why would we have a process where there is nothing that the developers are getting in line for, while we're requiring yet another application process?
And I can understand your point if there weren't other factors in play, and that's so it actually is making me think that this is an issue that's really worth exploring further. I was really intrigued by the readiness bar, and the fact that there could be abuse in the interconnection process.
I
And
can address that, Your Honor.
right, and but it just seems to me that if there's a way to resolve some of those issues, and it sounds like perhaps the community solar interconnection queuing process is dealing with some of that. It may be that and you don't think that that's the case.
And again, Commissioner, I would urge the commission to trust the expertise on this issue of the individuals who are tasked with managing these queues. And we have our SMEs here. And I've spent considerable time speaking to them and dealing with their difficulties on a day-to-day basis. And this idea that there's going to be a problem getting hosting capacity through the interconnection queue, I've asked our SMEs this morning in his infinite years at the company doing this, how many times has a customer have to come before the commission and ask them for an extension of the interconnection queue deadline because the utilities wouldn't give it to them. We work hand in hand with our interconnection customers, right? And that last hearing with 10 Oaks, the company 10 Oaks stood before this commission and explained how BGE was working with them for several years to get this project up and running. This is not an ask where BGE is trying to prevent these projects from getting up and running. I think this actually goes to support Maryland's goal of getting these projects up and running in an efficient manner.
But it actually sounds like, I mean, other than the 12-month sort of interconnection process and then 6-month extensions, it sounds like there are also some concerns that you don't have control over, which is sort of applicants that come in and simply sort of occupy a space and are not serious projects. And I mean, it just seems to me that, I mean, especially with Mr. Vanderheyden saying we don't have to resolve this issue to get the rulemaking sort of up and finalized. It seems to me that this is something that maybe needs to be taken back and worked on a little bit more, because I think that the abuse in the interconnection process is maybe something we need to think about, and maybe there's a way in which you can take all the things that the community solar queue has learned and apply that to the interconnection process as a whole. But all I'm saying is it may be this may be too big an issue to be able to resolve today.
Yeah, Your Honor, I would say this. Again, there is no abuse that, and I can speak particularly for BGE, of the interconnection process as we have it today. And I mean, if there is any abuse of the interconnection process today, the community solar queue doesn't solve that, because again, those projects that go through the community solar queue, they have to go through the interconnection queue as well. It's not one or the other, right? So I don't think maintaining the community solar queue addresses any abuse in the interconnection queue, because those same projects have to go through the interconnection queue. And with respect to the timelines in the interconnection queue, yes, it is in an initial 12 months. But unlike the community solar queue regulations, the utility have actually more discretion to grant extensions of the applicable timeline. So we can work with these developers and work with these projects, and as long as they show that there are signs of them moving along, we can grant those 6-month extensions. And I would add that we are already fielding requests for extensions under the community solar pilot queue. It's not like we're not already doing that. It's just under a different queue, an additional queue. So we're fielding requests from interconnection customers, but then we have a separate application process and a separate queue, the community solar pilot queue, where we have to field requests from developers within that queue. All of this just spells inefficiency. And in terms of the safeguards, the community solar queue, as Mr. Bugelman mentioned, does require proof of site control and some evidence that the developer has applied for certain permitting. If the commission sees value in that, the easy fix to that concern is to simply require that for community solar developers in the interconnection queue. It's just documentation that they can submit through one application process as opposed to two different application processes.
Mr. Bugelmans, I'd love to hear your response, but just Mr. Michelle, that's actually one. Your last point is actually one of the reasons why I think taking it back and speaking to how to make this process better, whether it's two processes or one, I think sort of for me speaks to why it's too early to deal with this issue. But
Commissioner, I will try to respond, and if I don't touch on what you're interested in, please follow up with me. I think my first point I'd like to make is that the first edit we are going to look at in these regulations is a provision in the interconnection regs, not in the community solar regs, that says that community solar projects are exempt from the interconnection timelines. In my understanding of why it says that, and that's how it is under the pilot, all the proposed edits do is make it say permanent program instead of pilot program to just be consistent with the fact we're now in a permanent program. But that was done to effectively swap out the interconnection timelines that exist for the community solar queue timelines. So it is true that as part of the development process, developers first need to submit for interconnection. That is its own application. They have to get their conditional interconnection approval, and then they can apply for a queue position by providing proof of site control and the proof of application for a permit. But they really become one process. From a developer standpoint, once you get a queue position in the community solar program, your interconnection position is held for either 24 months, you pay the deposit, 36 months. So again, going back to one of my initial points, we know that 12 months is not enough. For almost any project I'm aware of, 12 months would not be enough time to develop the project. Maybe a rooftop project, but any other site, there's no way. So we're faced with agreeing to 12 months, which we know is completely inadequate, or keeping things where they are, which again, it's tough for some projects. We have to come in for extension requests, but it's reasonable and we're comfortable with it. I think to the broader questions you raised about, maybe there should be a harder look given to this. I think as an industry, we agree. And in the Turning Point docket, we submitted comments related to the SO process and ways that could be improved. And there's some interplay between the utility applications for queue positions and staff's SO process. And so we agree that it'd be worth to take things back and take a broader look at the entire process. There's obviously some key aspects of the current process we support, the deadlines, the readiness bar, and maybe that could lead to more comprehensive reforms related to interconnection for all solar projects. But at this point, we think the current process just works, and we're clearly not ready to do a comprehensive change to everything. But we agree that a lot of these issues do deserve further consideration, again, separate from this process.
okay, that's all I have.
Is there any other questions? So, just so I understand this, are we talking about two parallel processes that eventually intersect, or how does this thing work?
That's the way I view it. Just
Okay.
from
So let me start with him, and then
Okay.
I'll come back to you.
Yes.
So,
Chair Hoover, that's a great question, because I literally sat with a developer yesterday trying to make sense of how these two processes works. And there are some who will say there are parallel processes that eventually merge together. There are some who say that it's two separate processes. No matter how you view it, as Mr. Bugelman acknowledged, in these three application requirements, there is considerable overlap. And our suggestion is meant to do away with those inefficiencies and to streamline things. And again, with respect to the 12-month deadlines that's currently in the interconnection queue, I think that focus is misplaced because, again, the developer has the ability to simply make a request, as they do today, to the utility, and the utility has the ability to grant that extension instead of having the developers have to come before this commission to hear these extension requests. And again, I haven't heard to date any developer or any interconnection customer complain that the utilities were unreasonably denying extension requests.
So, Mr. Bugelmans.
So again, from my perspective, working with developers, I do view it as they're two separate processes that combine together. Because again, once you get the conditional interconnection approval, you apply for a queue position in the community solar program with the utility. That starts the 24-month clock, which can be extended to 36 months. So internally within the utility, maybe it's different teams. I really don't have much visibility into that. But from a development perspective, that's how I view it. And my impression is most developers view it that way as well.
Okay. And staff's view on sort of how this thing works operationally?
So I think the point that we have a system that we're doing now that's based on what was done in the pilot, and it's probably would be best to leave that in place for now. The issue as to how to make adjustments to this going forward is probably something that can be handled either within this working group or within that the 9720 case that was mentioned. There is, I think, an important issue to maintain a project queue, so separate from the interconnection queue. The project queue probably has an impact when we get close to the 3,000 megawatt cap. And there's a sort of a big policy call that needs to be talked about and worked out, which is which projects will fit under the cap. Is it based on when they become operating, or is it based on the date they applied, and how does it apply differently for rooftop solar from community solar from aggregate net metering? That is not yet in front of you in these rules, in a direct way, but we will need to figure that out amongst all the stakeholders and get a good answer. So if we get rid of that queue, we sort of lose track of like where projects stand if it were to become important to begin tracking when they become operational versus when they made application. So I think we are definitely leaning towards leaving the existing process in place for the purpose of application and not adopting the changes that have been proposed by the utilities here.
So, Mr. Michelle, let me ask you, do you have any, and I don't want to put you on the spot, but if we deferred this to the work group, do you think there is a possibility that some accommodation can be made that solves your concerns but still takes care of theirs?
I do, Chair Hoover, and my only concern with deferring it is, at times things, and the commissioner is familiar with this, things get kicked down and kicked down and kicked down, and we're dealing with the same questions in the work group. What I would propose is that this issue be dealt with in, I believe there's a phase 2 rulemaking to deal with consolidated billing, that this issue gets kicked back to the work group to be decided by the commission when we have that second rulemaking.
Does that work for you guys?
Yeah, this is Charlie, Chair Hoover and Commissioners.
Actually, I need your full name.
Sorry, Charlie Cogshaw. Yeah.
Mm-hmm.
Charlie Cogshaw, Mid-Atlantic Director, Coalition for Community Solar Access. I think that's okay. I only hesitate a little bit there because we have called out in 9720 a number of different areas that we view as improvements that could make the process more efficient. They don't specifically get at exactly what Mr. Michelle's like calling out the change that he's calling out. In fact, all of the changes I think that we've flagged in 9720 could be done outside of the regulations through administrative processes changes. And so I'm a little hesitant to. I'm not going to make any promises. But I will promise that we will continue discussing the utility proposal, and we have. We've worked with them separately. We have a concerted interest, a similar interest in efficiencies in this process. But for all the reasons that have been laid out by Mr. Bugelmans and also Mr. Vanderheyden, we're concerned with making a big change up right now when we're 6 months away from the permanent program coming into place. So we can't make promises. We will absolutely continue discussions, but we can't make promises that we're going to be supporting more changes.
If I could echo just one point, the issue of where we got with the initial work group process was it was sort of just two opposed positions, right? It was maintain the current queue process. The utilities were just stuck on deleting it. Right. But as Mr. Kogashal indicated, it really is a broader discussion. It's the queue potentially and how the SO process fits into that. So that broader discussion is, I think, where the potential for major improvements could come from. But it's not just this one issue. Are we going to agree to something which clearly we can't, which is to, remove the queue process?
Okay, so we'll allow the work group to take a crack at it. If you can't fix it, then when we come around this second time around, we'll make the decision on it.
If it's to the commission's agreement, what we could do is if we identify particular policy issues,
Sure.
we may want to come to an admin meeting and say, here's a policy issue, and could you give us some guidance?
Yeah.
And then that will help.
Yeah, feel free to do that. That's fine. One other issue before we get into the document. So the issue that was raised by MEA and OPC about the data request. I mean, my understanding was that there's some concern on the part of the industry, I guess, of a flood of requests. I mean, I guess it strikes me, and obviously I'm somewhat biased on this, that this is not an unreasonable request by the two of them, but I guess I'm willing to hear if there is some rationale about why you shouldn't do this.
Sure. Happy to respond to that. Our concern is that OPC has effectively requested unlimited authority to send any project developer data request for any reason at any time with no commission oversight. Typically, when there's discovery and there's a third party that wants to engage in discovery, it's in a litigated commission proceeding. There's lawyers in place to respond to those data requests. If there's confidential data, there needs to be a protective agreement. Developers take compliance with regulations and obviously the laws related to development very seriously. But they are not prepared to be on notice 24/7 as if they're in the middle of a litigated rate case to respond to data requests from OPC. So it's just, to us, it's a very unusual request because it's outside of any type of actual commission proceeding, and we do have something to base our concern on. OPC's tried to do this before, and when they've tried to ask these questions, it's things like, what is the profit margin for projects? What is the minimum reasonable rate of return for projects? Things like that are extremely concerning. So part of what our concern is just what we've seen and where this could go. Again, Maryland's proven to be a difficult place to develop projects. We just think developers should be focused on developing projects, not responding to data requests. And again, there's reporting requirements in the regulations that exist now for project information that needs to go to staff in OPC or staff in MEA, and OPC can obtain that information. But just the idea of unlimited data request authority is extremely problematic for the industry.
Okay. And then I'll come back to you.
Honorable Commission, John Miller with Chaberton Energy again. Yes, I want to underline that point that David just said. The request that came in sometime in the last year was very aggressive in terms of the information they wanted. Essentially, as a private business, we were opening our books if we were to respond to that request. It was information that we would never give our competitors. We don't even give to some people within our own company in terms of project level financials that are highly, highly sensitive and what we would consider highly confidential. So Chaberton's comment to their request is that we're fine with giving information to MEA, OPC, and all the other government acronyms, but we think the information they can request should be specifically defined and laid out by this commission. You should have the ability to say this is the information that they can ask for, and that's all that we're required to respond to. Leaving it open-ended leaves us open to having requests comes in with that are requesting improper information from a private company. Thank you.
So,
Thank you, Mr. Chairman. OPC does believe that it is important for there to be a right under COMAR for it to issue discovery requests to the companies. I would disagree with the characterization that it would that previous data requests would require the subscriber organizations to open their books. And I think that the vast majority of the questions in that set that was just referred to had to do with basic information needed for OPC to make a determination that the program, and when it was in its pilot stage, was moving forward with the intent that the legislature had when they enacted the program. We think that as the program moves forward on a permanent basis, we're going to continue to have an interest in monitoring the program, and we do believe that having the request directed through staff is just very logistically challenging and would burden staff, frankly, with the type of data requests that typically go from the party that's requesting the information to the party that is in possession of the information. I would also disagree with the characterization that the data requests that the Office of People's Counsel and MEA would be sending out would be outside of commission oversight. We believe that there is a proceeding that the information would be requested in. It would be the RM56 proceeding, the community solar pilot program. The questions would be directed at the company's compliance and operations within the community solar program, and in OPC's case, they would be directed at information needed to ascertain the impact of the program on the residential ratepayers of the utilities where the subscriber organizations are operating.
I think so. Mr. Tolson left. I'm assuming that MEA's role in this process is not so much cheerleader, but at least proponent, advocate of increased renewable generation. So I guess I'm wondering why questions from them would be problematic for applicants, because I don't view them as wanting to be hostile to the development of these types of projects. And I understand the concern that the private companies have about confidential information and things like that, but you're in sort of a hybrid situation. I mean, you're not a utility, but this is not just the open market. So I think there is a need for the companies to be forthcoming with information that could be considered relevant for making the determinations about certifying projects and making sure that they're complying with the parts of the law. Because part of the understanding with the community solar projects is there's a certain requirement you have to meet. It's not just a regular old utility scale solar project. And so I think there is a need to make sure that, from OPC's standpoint, that some of those parameters related to low income participation and things like that are being made. I'm hesitant to try to figure out, a sort of draw a line in the sand, like, questions on this subject are not permitted. But on the other hand, I'm, open to the idea of trying to create some sort of process that if there is a question that you think is not proper, that you could get quick adjudication from us as to whether or not you have to respond to it. Well, go ahead.
Yeah, I actually have a question for OPC, and that is, I'm just not understanding what you want to know. I don't understand what you're seeking to get information about.
So, in the past, we have sought information about LMI participation. We've sent data requests seeking information about contract terms. Part of that is to understand what the market looks like from the consumer's perspective. The only other way we would have to obtain that information, I guess, is to try to seek out the offers, which we've actually received a lot of questions from the public about the difficulty they've had in researching community solar projects. There isn't, at this point, the same level of shopping assistance as the Commission has done with retail choice, for example. So the questions would be questions that would be impactful to residential customers. I've mentioned LMI. There could be questions about the the level, the changes that we're suggesting would allow OPC to get information not only from subscriber organizations but also from electric companies. So we have questions about the impact of the way the residential rate credits are being recovered. The cost of those credits are being recovered from other ratepayers. So that would be a line of inquiry that I think we would be interested in exploring as the program moves forward on a permanent basis. But we don't think that drawing a line in the sand and saying, well, you can ask questions about LMI participation or the way the cost recovery for the program is working, but nothing else. We think we should have the flexibility to ask questions that we feel are necessary in order to carry out our statutory mandate. And as Mr. Chairman just mentioned, the protection that would be in place would be in what we would imagine the rare circumstances where a subscriber organization or electric company has an issue with a particular question. That happens actually in discovery and docketed proceedings as well. And those disagreements are usually resolved between the parties without requiring the Commission to be involved. And I would expect that would be the case.
I mean, it sounds to me as if it would become standard operating procedure to ask all of the subscriber organizations all these questions as a matter of course. You wouldn't be picking and choosing. You'd be asking everybody all this, right?
I think that there would be many circumstances, especially in the beginning, where there would be batch requests to all of the participants in the market. But I think when it comes to follow-up questions about particular contract structures or particular methods that the subscriber organization uses to verify income for the purposes of LMI participation, for example, that there could be some specific particular questions that are directed solely at a particular subscriber organization.
And do you regard these as data requests that are simple and easy to comply with? Let me tell you, I have a little bit of a bias here. In a prior life, as a CFO of a company, it was my job to fill out all these forms, and you'd be amazed at how much time it can take up. So I guess your position is that these are simple, easy responses on the part of the developers and subscriber organizations?
I think that's right, because and then to the extent that they were not, or that we didn't realize that the way we worded a data request that it was overly broad, those sorts of disputes are usually resolved between the parties, and the data request is amended or modified, or some exception is given. But yes, I do think that generally speaking, the questions would be the type of questions that would allow us to make apples to apples comparison to understand how the market for community solar subscriptions is working. And I also think that the fear that there would be this deluge of data requests that would just be going on an ongoing basis is unfounded. I mean, we just don't have the resources to constantly send out data requests week after week to have the CFOs of various subscriber organizations complete.
Okay, thank you.
See, it seems to me that because we're dealing with the LMI community, and because of OPC's responsibility in protecting customers that are not sophisticated, that in order for them to do their job, they're going to need to have access to information that gives them assurances that the customers are protected. I'm just sort of wondering if there's a path forward, and maybe this is another one where we send it back. And I mean, you understand that they can't do their job if they can't. If this is not, because what you're doing, because community solar is so integrated into the LMI world, and because this is the mandate of OPC. I just find it really hard to understand how they can do their job if they can't get access to the information that gives them assurances that the folks that they are mandated to protect are in fact being protected.
So if I could respond briefly to that. Our concern is informed by the data requests that OPC sent to probably thousands of developers in 2023. And among those questions were questions like, document the return on investment your organization has received on CSEGs in Maryland by year, and provide all financial documents supporting your claim. Questions like, what compensation rate / bill credit does your organization need to earn a reasonable return? Provide documentation to support your position. And when that came in, it was an industry-wide crisis trying to figure out what to do. Those are the questions we are concerned about.
If you think that there's an abuse, you can come to us. I mean, it's not a comply or not comply. I mean, the problem is you're giving me an example that is supposed to demonstrate that OPC should get access to no information, and that can't be the result. So I mean, maybe you can sort of take this back and have a conversation, but the reality is that if you think that OPC is abusing the process, you just come to us and say, that they're asking for things that are so out of the bounds of what they need, and then if we agree, we will deny the request.
Well, actually, let me offer a variation on that theme, and you can sort of give me your thoughts as to what process you'd like to do. Meaning, we can, like with the previous issue, send this back to the work group if you think there's some way for you to construct some arrangement between you, OPC, and MEA that you can live with, going forward. The alternative is, and admittedly I'm free associating on this, is we could designate one of the public utility law judges to basically be the individual who, if you have a concern with a question that's been asked of you that you don't want to respond to, you could go to that public utility law judge and get a ruling relatively quickly, as opposed, I mean, I know the concern about coming to us is delay and all that sort of stuff. So this might be, and again, I haven't talked this over with the chief judge, but, there may be a way to construct a process like that where you would get an answer right away. Yes, you got an answer, or no, don't bother about it.
So a couple additional points. In our experience, my understanding from CCSA is that no market has a requirement that's open-ended like this. Mm-hmm. I think one thing that's also true with the current regulations is there is a recurring reporting requirement placed on projects. And one of our biggest concerns is that, again, we're talking about hundreds and hundreds of developers that would need to respond to questions like this. And if there's an issue, bring it in front of the commission or a judge. One thing we could possibly do is take this back with your direction, which is, I think, clear from many of the commissioners, there's an interest in OPC being able to obtain information, maybe come up with potentially a consensus list of the things that OPC wants. And maybe the industry could agree to it, and we could put it in front of the commission, and then add it to that recurring obligation. Again, we need to see what that is. I can't make any promises, but maybe that's a way to address your concerns without just having this be completely open-ended, where really at any time there could be discovery propounded on hundreds of developers.
Mr. Bugelmans, I wonder if we can add to that so that and perhaps this is the list of things that you need to provide when you do the application. So there'll be kind of you'll sort of come up with a list. And then maybe there are going to be issues that are going to come up, so that we can perhaps put in or you can put in the regulations that OPC can come to us and ask for the ability to do some additional discovery. So that it wouldn't be an automatic. So there would be some measure of control. So that there'd be sort of so the default is you'll provide all of the information on LMI and whatever you come up with, and this is something we don't have to make a decision on today, but perhaps sort of take it back as a so that there is a path forward for OPC to the extent that they have identified some additional information that they think they need to be able to protect consumers, but they'll have to come to us to ask for that information. But I'm just.
Does that work for you? Or?
Yeah, this is Charlie. I think that does. I do want to just make one important point here, which is that HB 908 requires all LMI customers to have at a minimum a 10% discount relative to the credit value they're receiving. So there isn't going to be, they can't get kind of screwed over by the subscriber organizations. They have to have a savings. And actually all residential customers cannot have a premium. It's got to be savings. This isn't the case. There isn't this sort of similar risk that have been highlighted with kind of the retail supply world. This is like community solar is required to make savings for residential LMI customers. And so I want to just sort of emphasize that's not kind of a risk here. And the data requests that our members and other non-members too, who are just participating in the market, got a year or so ago, that wasn't the focus of the data request. It wasn't kind of what kind of discount rates are you providing to the customers. It wasn't so focused kind of on the impact to the customer. It was focused on kind of what do the books look like for your company for these projects, how much do they cost, what's your return, and so that raises kind of questions on the intent of what was the purpose, and so I think we're open definitely to having kind of continued conversations about what might make sense for sort of a reasonable data collection that OPC would align with their interests. But I do just want to emphasize that the market's protected in ways that HB 908 has already built into it, and that we want to make sure that I'm protecting my members and the industry developers to keep their kind of financial information private, but be participating as good actors in the market from a customer standpoint.
Okay, so going forward, you guys get together and see if you can figure this out, and if not, then like on the other issue, we'll ultimately figure it out. So with that, there's no other sort of overarching issues that we have to talk about, or can we now move?
I think it's probably the rest of them are sort of specific point items.
So I guess what I was thinking about doing was before we sort of dive into the document, maybe we should take a break for lunch, and we'll come back at 1:40. Okay. The record for rulemaking 56, Mr. Vanderheyden.
Good afternoon, Mr. Chair and Commissioners. So I propose what we're going to do is walk through this document. This is the filing that we made without any changes to it. I have it in a Word document up on the screen, and as we make edits to it, I will either add comments or strike or add language as desired. So just going back up to the top, there is a table of contents, which is not normally a feature of COMAR, but if you're following along the documents, each of the sections has a place on the table of contents page. You can always go back there and kind of see where we get to things. The first section we're going to address, and I will bring up one other thing before we dive into it, is we are working in both 2050 and 2062. 2062 is the majority of the changes. That's community solar. 2050 is, I think, the subtitle is for service provided by electric companies, and 09 is small generated interconnection standards, of which we're touching here. We also have a sort of a add-on edit to 2050-10, which I will put up on the screen when it's appropriate to do so, which is making a housekeeping correction to change the 1,500 megawatts, which is the former statewide net metering capacity, to 3,000. So maybe we'll just touch on that when we get to the end. And then there's also a place when we get into the document, there's a proposal to move something from a section of 2062 to an identical or new section in 2050-10. And so I'll put those up on the screen when we get to that, but that is not in the original filing. That's something that was discussed last week by the working group as a means of reaching a potential consensus in one area. Mm-hmm. So the first thing we're going to touch on is in 2050-09. This is, we sort of addressed this already, but I'll go through each thing and we can sort of describe how we want to approach it there. So this is language that, as mentioned earlier in the discussion, this is the interconnection standards, and this is, if you look at, it's B3, or I'm sorry, it's M. So we're in 2050-09, Regulation 06 General, Section M, Validity of Conditional Approval. This is just language which exempts the community solar from the 6-month language, and based on your previous discussion, the proposed change by BG&E and P and PHI would be to delete this paragraph, which would subject community solar to the same deadlines as interconnections for every other type of generation. So based on your previous discussion, this is where you would make the call to take this, adopt the yellow, which is otherwise compliant with the law, in that it would sort of retain the existing procedures for the community solar, and they'd be exempt from this.
Okay.
Mr. Chair, if I just may make a suggestion for the sake of efficiency, there are a number of proposed revisions that deal with the discussion we had earlier about whether or not to do away with the community solar pilot queue. Instead of going through all of them individually and sort of describing what they are, we could, since the commission has already ruled on kicking this back to the working group, we could probably just skip those for now and deal with the sections where we're asking the commission to actually make a decision today.
Does that make sense?
Yes, and so, I mean, you'd be, I think, I'm not sure if that means we are adopting the language that's shown as consensus here, which sort of is necessary because this references the pilot program. So I think what, in order to take this back to the working group, we would have to decide on something and then make additional changes on top of what is being done today to address that in the future. Because otherwise, the language in 3, which is simply making the change from pilot program to program, we wouldn't be making that. But I think we need to do that in order to switch, so we're no longer referencing in COMAR the pilot program.
If I could speak, Your Honor. So along the lines of what Mr. Vanderheyden said, this is a required conforming change to accommodate the fact that we're no longer in the pilot and now we're in the permanent program. That's all this does. Again, it's consistent with CCSA's proposal, which was to keep the current queue process and deadlines. In my mind, it would make sense to adopt the yellow language. And then obviously we've received the direction from the commission to, in addition to this queue issue, the deadline issue, sort of re-examine everything holistically. And then, maybe one day we could revisit this. But if the goal is in this rulemaking to kind of continue things as they are, which is what I thought I heard, I think it's essential to make this change. And there's several other areas where there's changes like this. Again, just changing out terms, we're no longer in a pilot, it's a permanent program. That's the intent of this.
Yeah, that's consistent with what I was suggesting. Maybe it was the lack of clarity. My intention was to not have to go through the language that is consensus, which would be the yellow. If all parties agree, we can just move things along.
Okay. All right, that works.
As I go through here, just to keep notes, I'm going to strike through things that we are not continuing with. And unless otherwise noted, we're adopting the yellow changes.
Okay.
Okay, all right, so
All right.
that is the first one. The next page is on page 7. All right, so this is, I believe this is now a consensus based on our discussion for last week, but there was a desire to have a definition of CAD, which is referenced as CAD, and a couple of regulations further down.
Yep. Okay.
So I'm going to change that highlight to yellow. Next one, I believe, is on, if you have any questions regarding the yellow stuff, there's a fair amount of language that is being changed. The next, we're going to go to page 11 for the next non-consensus change. All right, so this is what is sort of clarifying. We have the existing 3 categories. There's the LMI, the open, and the SBO category. What the law is addressing, it says that we're going to continue to use the same. If a project's waitlisted, it retains its same position in the queue. This is just clarifying that we are going to use the date and time of application because we have to collapse the 3 separate category queues into a single queue for that purpose. I believe this is, aside from the utilities reservations on maintaining a queue itself, that this is a clarification that folks are supportive of.
That work? Okay.
All right, my next page is 13. All right, I believe this is now, no one is objecting to this. This is making it a little more clear as to the language originally stated it's just may not end. Now it's the language in B, which you see right above the text box, was what was originally proposed as shall operate indefinitely. We'd proposed some language that would make this a little more clear in that it would read, so the B up above, as right here, would be replaced with the language that's in green, and it would state now that an electric company operating a CGIS program shall continue to operate the program subject to Public Utilities Article 7-306.2 or an applicable commission order. And I believe that is now consensus.
I have a question. Why isn't shall operate indefinitely unclear?
Because if the law changes or some other aspect that makes the commission, alter that, we would need to change this rule in order to enact that.
Okay.
All right.
Let me just make the notation. I'm going to strike out the language, and this is now Okay, I believe we go to page 18. All right, so if we are proceeding with not adopting the language that was proposed by the utilities, I don't know, maybe Mr. Mike McKell, are you okay with leaving this as is, or is this separate from the development of the queue? You want to talk about this one?
I'm going to actually have to confer with my SMEs on this one.
Okay.
All right, while he's doing that, just to sort of scrolling back up to the top, and you can see what's going on here. So, the that struck through that our convention is to use the brackets, but this is with such a lengthy piece that was removed. I struck it through just so we wouldn't lose track. But this entire section is sort of being removed and replaced. The language here that starts with A, and this, sorry, I have to go back up to the top to get you the title here. But this entire section was originally program generating capacity. Now it addressed project lists, and so as you can see, we're taking out starting with A, moving all the way down, and some of this is being revised. So the new A is here, and it just says electric company shall maintain a list of accepted projects in total. Now it'll say program capacity and service territory. The language I think that is being proposed as the compliance language is reordering some numbers, and it's taking out any references to the pilot being closed. That's what you see in C1, and then 2 is requiring it to be posted on the website, and there's sort of a permissiveness for the utility to, instead of providing it, post it on the website unless the commission directs otherwise. And I think it was the posting of all that the utility folks had some concerns with, and they wanted to, but it also tied in with sort of maintaining the queue, so I think that was part of the reason for objecting to it. So I think what we would want to address, and we'll have to touch on C because there's a slightly different issue there, is to whether or not we're going to sort of leave the existing reporting requirements in place. I think aside from the utility, I believe the solar folks are good with this language.
That is correct. We are good with the yellow language. I suppose BG has to speak for itself. My understanding is that their alternative language would accommodate the removal of the queues. But if the commission has decided to maintain the queues, at least until we come back later, then I think it would make sense to use the yellow language. But we'll wait to hear what BG says.
Oh, I'm sorry. I missed it. I'm back. So this item is actually separate from the question of whether or not the queue should be eliminated. And I think it's the Exline Utilities suggested revision is simply to clarify how this information is being supplied. So note in that box there, and Phil, you might have to scroll to section B. What we're proposing in addition to that highlighted language is that the requirement in section B is deleted.
Is it the notation of accepted versus notified? Isn't that really where this was going with yours? See how like
No,
top
that-
after
Yep.
Sonat's website of accepted, you were pulling out accepted because you didn't want those accepted because there wasn't a queue?
Sure, but the crux of our revision is not the term accepted. It's posted on its website, so that's to clarify how we are providing the information. And then related to that is the suggestion there that section B be deleted. I don't know if you can
You want to, okay.
show
let me
section
scroll
B.
here.
So at the bottom of page 17 there, that section would be deleted.
Again,
And yeah, I was just going to say, and the rationale behind deleting section B is that if the information is going to be posted on the utilities website, this provision here becomes obsolete.
Right, I think we were trying to address that the commission still wants, and or if, a party, like, one of the parties that has to do some of the reporting actually wants the provision of the list, this would leave it there. I think the complication that we were looking at was both of those things, as well as the sort of language which removed accepted. So are you suggesting maybe that you're looking for a change that would leave accepted in, but just get rid of the requirement entirely to provide the list every year?
Yes.
And only post it on the website?
Yes. If the commission has decided that we postpone the decision on eliminating the community solar queue, we can maintain the term accepted, but still deal with the other proposed revision.
That work for you? Or?
If the idea is to delete only B1, which is the requirement to provide the queues to the commission, CCSA is comfortable with that deletion. The key thing from an industry perspective is having the project lists regularly maintained on the utility websites. So we wouldn't oppose that deletion. Obviously, if the commission wants that filing, that would be fine as well. But we would be fine with deleting that.
Okay. Does that work?
That works. Yeah.
Okay, all right.
All right, let me figure out how I'm gonna. All right, so we're taking out B1.
Correct. And then in terms of that box, you're keeping everything except the term accepted is remaining.
All right, so we can get rid of B2 then as well, right?
Yes. Yep. Section B. Yep.
Did that. All right, and so what we're going to adopt here is the language posted on its website, and we're leaving the word accepted in. Is that correct?
Correct.
Now, what are we doing with in total?
That should be deleted. And total pilot program capacity should be deleted, obviously, because it's a permanent program and there's no capacity limits.
All right. CCSA or
Yeah.
David, you guys okay with taking out the program capacity? I think, is that picked up in the section we have later?
Right. I think this is fine. We were just trying to piece together, because there's so many moving parts, where this fits in. But the totality of the language that I think would be adopted is okay. I'm just wondering, where does A fit into the earlier language? I'm sorry, Mr. Vanderheyden. I mean,
Yeah,
you
sure,
could
no
scroll.
problem. So we have A says.
So that would be A. That would be
That's-
maintained.
Yeah, I have to take out the A because this is the new A. See, it said each company shall maintain a list of accepted products and the total program capacity.
Got
So
it.
that was two elements.
Got it. Okay.
And what was being proposed is to take out accepted projects and total program capacity. So now we're going to get a list of projects, but we won't get the, here is not the requirement if we take out A for the total capacity.
Right, that's fine.
So this is all out.
I mean, we want to know the capacity too, right? Yeah, but they're like the project list. Yeah.
I'll just say adopted.
There's going to be sizes of projects. So, I mean, I think
And we're moving this.
capacity for the permanent program. Yeah,
Um,
as long as there's a way to count it. And there's the reporting stuff later. So, which I think we're going to
Okay. And then the PE language, I guess P is happy with the BG&E adjustment.
So, yeah, Jessica Reba for P. So our intent in that was actually had to do with the Q. So we will abandon our proposal for now and support the VGE change with one clarification that currently we provide the list twice a year. And we just want to make sure that the way this new A is worded, there's not an expectation that we will be updating it more frequently than that. So if you go to the B that we deleted, the list had to be provided the first business day after June 30th and December 1st of each year. It's our understanding that that would still be the expectation, but now that we're deleting that, we just want to make sure we're all on the same page.
There's another section. Yeah. There's another section, I think, right?
Yeah, we are going to address sort of the tracking element, but I think generally this list is meant to be up to date, like as it gets changed, right?
Yeah.
Yeah, you
So
had
it's
said,
not-
yeah.
So the new requirement would imply that the posting of the list of projects, you add a project or remove a project as soon as possible. That's corrected. The original was send us a list at the beginning of the year and at the end of June, and that's going away, but we are going to have, in lieu of that, an up-to-date, I think we get into it in more detail
Yeah.
later.
That's right, it's a different section.
Yeah.
Good afternoon, Chair and Commissioners. Mark Zuka for Potomac Edison. Just clarification, there are two sections here. This one is on the project list. There is a separate discussion of the project queue, which we are going to maintain. Those queues have a separate requirement that we'll be discussing here in a little bit. But this is more of a semi-annual report. We're just clarifying that we've always been able to do it on the website. We're now saying that that's the preferred method, but we're not saying that we should do this in any greater frequency than we currently do today. I think the queue discussion we can have when we get to the queue.
Okay, all right, that works.
So just to clarify that, the dates are going back in. If you don't put the dates in, you're gonna have a problem.
Yeah, our preference would certainly be for it to.
Right, so you put, I mean, if everybody's okay with putting the dates back in? Otherwise, someone's gonna have to go back to this proceeding and you don't wanna do that.
So, the dates are up on the screen here, this language.
The June, those dates, just the June and December dates.
All right, so I hate doing this on the fly, but I'm going to attempt it. So, something to the effect of each electric company shall maintain a list updated the first business day after June 30th and December 31st of each year. And just add that language in. Is that what works?
Yep, that works for us.
I apologize, I'm going to have to ask a question. So right now, when you take in new applicants, are they not entered on a list?
Not in real time on the project list that we're talking about in this section of the regulation.
But I'm talking, just put the regulations to the side for a moment. Do you not update your list when you get a new application?
We update the queue.
You update the queue,
Right.
okay. All right, thank you.
Yeah, so I think I think BG&E and Pepco and Delmarva simply post the queue and update it frequently. So PE is actually putting a separate list up there twice a year, or are you just updating your queue?
It's my understanding we only post the queue online. This is a separate section. So PE, I mean, we have been in line with trying to consolidate these requirements. If this requirement is met by having the queue, then we would suggest let's remove this entire requirement.
Yeah. That's something we could support. Frankly, when I initially spoke, like other folks here, maybe we were kind of we were confused a little bit by this. I mean, there's two separate requirements historically. There's the semi-annual or twice a year update, right, which would go to the commission, and then I think at some point there was language added that would allow that to be posted on the utility's website, and that was sufficient. And then there's also a requirement to keep an up-to-date queue. From our perspective, the up-to-date queue is what's important. That is handled later on in the regs. I think we'll have a discussion about that. With respect to this, we would be fine adding in the dates, like Commissioner Suchman indicated, or we could just delete this because there's already queues maintained on the websites. So in terms of clarity, in terms of what projects are, there, as long as that's up to date, it's effectively the same information.
The question is whether staff and commission need the semi-annual reports. Is that something, Mr. Vanderheyden, do you know if that's?
So,
I mean, it sounds like this is really information for us rather than for the parties.
So I think the desire to track the queue is something that the developers need to know because they need to see where locations are. The need to track the number of projects and the total capacity is something that anyone who is trying to keep tabs on how big the program is and how close it's getting to. Of course, with the pilot, we had limits, and we sort of wanted to verify that. Those limits are now all subject to just the 3,000 megawatt limit. This is not the only place we would deal with that. So I think we need to know, and there's and when we talk about C very quickly, we're going to talk about like what happens as we get close to the 3,000 megawatts and what we're going to do to make sure we don't go over that. That's like one of our little subtopics that we need to address. But I mean, we can always get this. I think maybe just getting rid of this for now would work. But we will probably need to come back to it and figure out how we're going to track the cap itself. So.
Okay. I mean, because if that's what we need, we just need to make sure it's somewhere. And redundancies are sort of a good thing to get rid of. So if we don't need it here, it sounds like that's a. But then just put a pin in it and recognize that you just need to, at the end of the day, make sure that you have the information that you need and the commission needs.
I mean, I think we can take it out and then we'll have to renumber this and maybe potentially retitle the regulation itself. But it's really just a matter of making sure we have a list. The utilities keep a list of the projects and the total capacity so that we can keep track of that. So this was more important perhaps for the pilot because they each had their own list, but we still need to track the total for statewide. But that gets picked up elsewhere. So.
Okay.
Subject to making sure this doesn't interfere with something else, I think we can get rid of that and make sure it's picked up in the rest of the sections. So I will just note then that we are going to just take out all of A and B for now. You guys okay with that? Okay.
The Exelon utilities are amenable to that.
All right, so. All right. Let's move on to C. So this language and the green staff is now, based on our discussion last week, we're going to withdraw that because it is a sort of a larger issue that we need to sort out and take back to the work group, according to my note here. But this just says that the commission may direct electric companies to close the program to new applications if the total net metering, including community solar and rooftop and aggregate net metering exceeds the limit described in the Public Utilities Article 7-306D, which is the 3,000 megawatt limit that we have statewide. So at a point in time when you're nowhere close to that, this is a good regulation. At a point in time when you approach the 3,000 megawatts, this could potentially allow you to have multiple sort of incursions above the 3,000 megawatt limit, because it just says if it exceeds. So what we had originally proposed, and we have now withdrawn it based on discussions with the working group, is that once the amount of operating community solar and net metering of all types got to 90% of the 3,000 megawatt limit, that the commission could direct the companies to close the program to new applications, which presumably would give you, in this case, 10% or 300 megawatts of capacity that could be within the queues that would still have time to reach operating status, and you could just, very closely monitor it and make sure you didn't go over. So there are, I guess, concerns about putting that into the law or into the regulations here, because it's, you're basically stopping new applications. And so we understood and we listened to what the folks said, so we're withdrawing at the moment, and I think we would otherwise leave this unchanged, and I'll let the utility folks explain what they would like for this. But I think we are strongly advocating for leaving the existing language in place, where it's the commission that directs the electric companies to close the program, and it's imperfect as to, it'd be like once we exceed it, which is not really perhaps what the law intends. We should stop to make sure it doesn't go over. And I don't know if the solar folks have anything they want to address on that issue. We have withdrawn the green language there, and then I think the utility folks want to talk about how they want to address this.
Sure. So the proposed edit from the Exxon Utilities is simply to give us some clarity in terms of what we can expect to happen if we reach the total statewide net meter generation capacity limit. We don't want to be in a position where we're continuing to accept projects and interconnect projects when we've reached that capacity. So the language suggested here makes clear that we can expect that the commission will close the program once we reach that capacity limit.
Okay. Does that work?
I guess the question I have is, what's the point of, so you're not proposing the shall? The commission.
Yes, we are. Yes, because that is what gives this provision an actual practical effect. The utilities will then understand that the commission will close the program where the utilities don't have to accept more programs once we reach the statewide limit. Otherwise, the statewide limit doesn't have any meaning.
I understand that. I'm uncomfortable about having a directive to the commission in regulation. I mean, and there may be other directives. I'm still relatively new to the commission, but usually when you have a directive, there are consequences to not acting. I mean, what if we don't act? Then are we going to get fined? I mean, I don't like shall in regulation that is directed to us. I mean, where's our general counsel when I need him? But so maybe you can wordsmith this in a way that doesn't mandate us in regulation to take action. I mean, certainly the legislature can do that,
Right.
But essentially you're telling us what to do. And I don't know that makes a whole lot of sense, because usually when there's a shall, there are consequences to not following the shall.
Yeah, so I certainly don't want to imply that we're trying to tell the commission what to do. These are would be the commission's regulations.
But
right?
the regulations generally don't apply to the commission. They apply to the folks where we regulate. I mean, unless there are, I mean, maybe there, I don't know. I could just tell you that I'm looking at this and I don't know. It's hard for me to imagine that you can't come up with some other language that says, you know, to the extent that the cap is reached, then these things will happen. I just don't feel comfortable by having language that tells us what to do, and suggests that there are consequences if we don't.
So I guess one suggestion, this is off the cuff here, would be that this language would state something to the effect of the utilities should stop accepting new programs when we've reached the statewide net meter generation limit.
And you'll have to define when that is. I mean, I'm assuming you're defining when that is.
Sure. I mean, I think that's part of the difficulty that we're trying to resolve here, is that potentially we could have a situation where we have reached the statewide limit, yet the utilities have no direction in
Okay.
terms of
How
what
about
we
if-
should do, whether we should stop accepting projects.
I have suggested language here. How about if you just flip it around and say, the program is closed when the cap is reached.
It's reached.
Period.
So, Your Honor,
We're amenable to that.
we could,
Well, I mean, or you could. I don't know that you necessarily have to. Do you feel like you need to wordsmith it now? I mean, maybe you want to take it back.
I'm going to make a suggestion, which is that I really think may is the right word to use here. And the reason is, we're going to get to this later in the rulemaking, but one thing the work group put together are a series of reporting requirements for utilities to report progress towards the cap. That involves not just community solar, but all projects that count towards the cap, so net metered projects. And the idea, I think, with that is it makes the commission the agency that collects the information, and then when we get close to the cap, that's when potentially the commission will need to do something to accommodate that. But that's something that will happen, 3-4 years in the future. And so I think it's important for the commission to maintain some discretion about what to do once we get up to that limit. Again, the commission may just say, it's going to be closed. Maybe there's something that needs to be done that's a little bit more nuanced, depending on where things are at. But I think that the key thing is that this doesn't exist in isolation. There's going to be a reporting requirement, so this will be tracked. And as we approach it, there's going to, I think, out of necessity, have to be some further discussion related to it. And the discretion, I think, would be useful.
Well, and I guess the question is the only solution to close the program? I mean, there may be other solutions, and so you may want to actually, I mean, perhaps this is just, when you get 10%, or when you're 90% of the way, maybe there's a proceeding to address how you want to deal with this, so that it's not, so the options may not be keep it open or close it. And there may be another, but I think, Mr. Michelle, I think what you would like is you just want to have in place some mechanism that looks at what to do when you get to the cap.
Precisely. And the reason being is that I believe the legislator had something in mind when they instituted a statewide cap.
Right. No,
Otherwise, the cap would be meaningless.
Right.
So the question becomes, what do we do as utilities when we reach that cap? Do we continue accepting programs into the accepting projects into the program?
Well, and you probably want an answer to that before you actually get to the cap.
Precisely.
And so it may be that maybe you have a trigger in mind where you're 90% of the way, then you have a hearing to address how to proceed forward without specifying what that is. And so I think that when you have language like close the program, you already have in place a solution that may not be where the commission is when the commission actually, whoever they are going to be, looks at it. So it sounds like what you'd like is a trigger for a process. and you just want to specify in the regulations that there will be a process in place, and this is the trigger for when that happens.
Yes, that could be a proposed solution, but this provision specifically speaks about when we have met the statewide capacity limits. And so it's not tying the commission's hand in terms of what it can do when we reach 90% or 95%, right? It's simply addressing the situation where, okay, we've noticed that we've reached the statewide limit. What do the utilities do?
And do you define the limit to be whatever capacity is in service, or is it the capacity that is in the queue?
I can answer that. The statute's written, it refers to operating projects.
Okay.
So which makes things complicated, right?
Oh,
Because
it makes it so you could have twice as many projects in the queue as you have, and then when you close it, you're presumably you're not going to close out the projects that are already in the queue, so you will necessarily exceed the limit.
So we need to figure out like how far in advance of 3,000 we should put the brakes on, and this language, like we withdrawn it because we heard that the 90% was scary to the developer, or not scary, but it wasn't certain enough. The language you got in front of you basically says once we get to 90% of the limit, we're going to stop taking new applications. That doesn't mean that you couldn't reopen, but maybe there's a better term for that. I think the problem is folks aren't comfortable with 90. Maybe they want it, I don't know if they want it higher or lower than that, but we haven't talked about that yet. I think we might benefit from taking this back and saying, do we want to, you're going to hear about how we're going to track, maybe even like weekly as we get close, how many systems are operating. And once we hit a certain threshold, there maybe should be sort of a directive that goes to the utilities. All right, we're at 90% of the cap. You should stop letting projects into your queue, and you should stop letting residential customers, apply for interconnection for rooftop until we see if we're going to go over the cap or not. Like, we need something like that. We have the law that made it permanent didn't talk about how to build something like that. This was a sort of a crude attempt to put something in the regs that would, you'd cross 90% and say, all right, stop taking new apps. And I think that was too severe maybe for what the solar folks were looking at it. So we should talk about where the right threshold is, and then figure out what a rule should be. Is it stop taking apps once they're operating? Is it stop taking apps once the queue is at a certain level?
Or simply have a proceeding to look to see what actions the commission should take, rather than specify here you have an action here, and that may not be the action that you want the commission to take 5 years from now, 10 years from now.
So is it perhaps a proposal to leave this language unchanged and just leave it unchanged and take it back and solve this problem and come back in the second rulemaking? Is that
leave it unchanged and remove the 90%.
Yeah, taking out the green
Yep.
stuff.
Yep.
Unless you want to leave operating.
Yeah, I think that's right. I think that's what, well, at least with the stakeholders, what we agreed to last week was we agree this is important and appreciate Mr. Vandenhaven proposing it because it is a concern, but we want to discuss it more because we didn't feel like this was the right solution, and also we're sensitive to the other solar segments in the net metering, under the net metering cap, and how they might want to weigh into this as well. I will flag though, we are going to get further down to what Mr. Bugelman's called out, which is that there's a whole nother section that discusses kind of the data collection associated with the net metering capacity, and there is actually an amount. It says when it hits 2,000, like kind of the frequency of the of sort of data collection from the commission could increase. It doesn't prescribe very specific process, but it does. That is sort of the idea, is that as we get closer, processes are going to probably have to start getting into place. But anyway, I think that additional discussion with the net metering working group makes sense here. And again, we're probably going to talk about this a little bit more later.
From a practical standpoint, though, hasn't the solution been that the General Assembly just kicks the cap up?
Potentially, yeah.
Yeah, and just to comment on the suggestion that we leave the language unchanged, the concern that we have with the original language is that as drafted, it's putting the onus on the utilities to determine whether the program is closed, or it doesn't address the fact that the entities would be applying to the commission.
Yeah, and then that's the concern I have,
Yeah.
and that's why I think going broader, so the commission may convene a proceeding to consider whether the program should, so that it is really, it may be, maybe the industry comes and says, we need you to consider it because we're getting close to that cap and we need to know what to do. Directing you. I mean, there's too much. There's too much direction in this about where things are supposed to go, as opposed to just sort of a recognition that as you get closer to the cap, you're going to have to start thinking about where we need to move forward.
Yeah, agreed, Commissioner. I think if we have something that assures us that something is going to happen, there's going to be a proceeding before we get to that cap, that would provide great comfort to the utilities.
Okay.
Should we take that back and come back with language
Yep.
that?
I think so, yeah.
So, for the purposes of.
Phil? Oh, sorry. Mark Zucker from Potomac Edison. If I can just make one suggestion, the proceeding you suggest, Commissioner Suchman, should be in the net metering regulations. I think others have mentioned that we're right now in 2062 for community solar. That proceeding would only make sense if it was regarding all net metering projects, which are subject to that cap.
The Exxon utilities agree with that as well.
Does it?
Next are physical therapy.
All right, so I will. I think if I'm getting this right, we're going to leave this language unchanged, other than renumbering, and take this issue back to the work group for the second rulemaking.
Right. Yeah.
And we are not adopting the stuff in the box. All right. All right, I think we're on page 21 for our next non-consensus item. I think this is now okay. Yeah. My notes from last week indicate that there were no objections to the green language at the top in what would be B. And what's going on here is they wanted some clarity that when you're measuring the output of the community solar array, it's actually must be a utility revenue meter that does it. So it says as measured by the electric company's meter, instead of just metered output, which left some to believe that maybe a customer's meter could do that. And my understanding, there are no objections to this language.
Seeing none?
All right. Page 23. All right. I think BG&E, you sent me there's an email that in response to this, can you go over what you meant there?
I believe this one was withdrawn, so this should be non-issue now.
Okay. All right, so we are pulling out the text box language, and B in its entirety, which is new, is now consensus.
Okay, wait a minute.
All right.
Not quite, sorry.
So-
What you were in line with.
So, I'm gonna get kicked if
Sure.
I am out of line here, but so this language with regard to the 200% cap was actually taken out of the statute last year. And all the utilities were required to file revised tariffs. So PE filed a tariff removing this 200% limit, which was subsequently approved by the commission. So we just need to clarify that if we're putting back into regulation the 200% cap that was removed from the statute, we will need to go back and refile tariffs to put that back in. I'm sorry if that's not clear, but
So, SB 143, I think, is where this happened. That was the thing that you've heard about this before, where they changed the accrual method from annual to a customer may choose either an annual or an indefinite accrual. So perhaps it was thought that it's no longer necessary to sort of track the total amount of one's baseline usage that could be contracted for. But at the same time, it's probably helpful to have a practical limit so that customers don't inadvertently buy too much, because more than 200% of your baseline, you'd be essentially either constructing a lot more solar than you would need, or you'd be purchasing that. So I think we would agree that that specific language was removed. It's not clear, at least to us when we look at the legislation, that there was an intent to actually remove the 200, other than to perhaps it was thought, like no one would want to encourage a customer to buy too much that what they needed. So this is probably still a useful regulation to keep in.
Any thoughts?
Sure, Chair Hoover. CCSA supports the 200% limit, basically for the reasons that Mr. Vanderheyden said. We think it is useful to have a limit so that customers can't be massively oversubscribed to output. SB 143 did remove the reference to 200% in the community solar statute, but the 200% limit has never been referenced in the net metering statute. That was a creation of the commission as a matter of policy, and it's a good policy. In fact, for community solar, it arguably makes more sense for this program than standard net metering. So we support it. We don't think SB 143 mandates it be removed.
Okay, all right.
All right.
so sorry. Leaving aside the fact that I would disagree with the fact that the legislature's intent was clear, I think we still have a problem with this language because, and I think this is what Exelon was getting at, was that it shouldn't be on the electric company to not apply the credits. Because I think it's really difficult for us to monitor and police that. I don't know if Exelon.
While they're thinking, we added B in order to address the concern that Exelon had about the electric company being in a position where they would have to apply credits because a customer subscribed more than 200. So the original in A was there to say, hey, subscriber, don't purchase more than 200. That's on you if you go over. And I think what the Exelon folks, and I'm sure they'll, when they're done talking, they'll figure out, the language was that what they were proposing was not receive credit, but the problem with that is sort of it's sort of like passive. So it should be clear in the regulation, this person should do this thing. And so we added B that says an electric company may not apply the credits. So if a customer somehow violates A and subscribes for more than 200, they are not obligated to apply more than 200 of those credits to their bill. And we thought that got everyone on the same page.
Well, it sounds like, I mean, the issue is one of whether, if the electric company is applying subscription credits, then this is what happens. This is not mandating that you apply it. So would that clarify, would that address your concern, is if the clause began to the extent an electric utility applies subscription credits, it shall not do more than 200%?
Yeah, I think that, I mean, you know, apart from the legal arguments that we were just talking about, there's a practical issue because, so the way this works for regular or for like a rooftop net metering is when somebody applies for a project, we look at their last 12 months and then what they're going to generate in a typical year with that new, there's kind of like a defined point in time where we can make that calculation. With community solar, they could be adding and subtracting subscriptions every month, and so that changes. So that's an ongoing calculation we'd have to make every month, not only with possibly multiple community solar subscriptions, but also potentially in addition to their.
But that doesn't, all this deals with is the fact that you're not going to apply if the amount exceeds 200%. I mean, that doesn't, this language doesn't address your issue. It's just very specific, and it seems to be something that's protecting the utilities. I mean, unless I'm missing something.
Yeah, I would not consider this to be something that's protecting the utilities, and I was unclear in terms of what the suggested edits or the highlighting of B, whether or not that was actually being suggested as something to keep or delete. I would actually be comfortable with deleting B for the reasons that PE stated. The onus shouldn't be on the electric company. If we're going to agree that the 200% limit should remain, the onus shouldn't be on the electric company to police that, right? I think the language in A, which says the subscriber may not subscribe for an amount of energy that exceeds 200%, that should be sufficient. B then turns around and suggests that the electric company now has a responsibility not to apply credits that the subscriber has subscribed for. That's our concern with B.
So are you thinking that you don't really need B, that A kind of takes care of it? Yeah, that kind of stuff. I mean, you could have, an electric utility is not required to, but that seems belt and suspenders.
So we're happy taking B out. That was added because we didn't like the way it was being formed because it was passive voice, but the proposed language is a subscriber may not receive credit. It's like, well, how does that happen? Well, it's really the electric company may not apply it. So if you take out B, I think we're happy because then somehow if a subscriber signs up for more than 200% and it gets applied to their bill, and then they can just choose indefinite accrual and they'll never lose the value of it. But when they move out of that house 10 years later and they only get paid for the commodity piece, which may have appreciated quite a bit by then, so who knows. But we're happy taking out B. That was intended to make the utility folks happier with what A still said, which we thought was useful to have.
We can agree with keeping A as it is and not adding B.
We're in agreement, yep.
Works for us, Your Honor.
Okay.
Okay, I think page 28 and 29, everything in the utility text box is now a consensus agreement from everyone. But I'll hold my anticipation until later. All right, so this here's language that talks about was talking about the sunset of the program. Now we're talking about project duration. So for B, C, and D. We'll get to E in a second. That is language that was proposed by the utility folks, and we all talked about it. And as modified, I think everyone's okay with all of the language inside the text boxes for B, C, and D, including the blue, the yellow, and the green.
Mr. Vanderhayden, this doesn't reflect. Remember, we discussed last week the addition of programs, so this covers both the pilot and the permanent program.
You're right.
So I think that was in the document that you sent by email, but it's not on this one.
I need to add that in.
But it's a straightforward, it's just a couple words.
So we are adding. Thank you for letting me pick that up. believe we are adding the words "or program" after pilot program in all three of these, right?
Yes, and remember that pilot program appears multiple times, so,
It's 2 in each.
yep.
Why is it not helping? We are adding this.
And just for clarity, the word program is defined in the regs to mean the permanent program. So pilot is defined as the pilot program, and then program means permanent program.
I see. Okay.
Okay, so I added it here on this line, pilot program or program. It is on the third line as well, and then continues over here. And we need to add the same thing in each place. In C and D.
So the one, I think, area that might need some clarity is that in the permanent program, the electric companies aren't actually granting capacity. So there might be some confusion. I want to make sure that this language doesn't.
Isn't that's sort of part of our global queue, reconfiguring problem, right?
No, I don't think. I think this is actually not something that's tied to whether or not we keep the community solar pilot queue. I think in terms of the construction of the permanent program as the legislator intended, there is no granting of capacity as the utilities see it, because there's no limits to the capacity. So that's the sort of lack of clarity, I think, that this language
Isn't that the
creates.
nature of being added to the queue is being granted
Right.
capacity?
We have a fundamental disagreement on that because, as I mentioned before, the legislator was clear in terms of removing the capacity limitations. So the utilities are not granting capacity.
I was going to suggest a simple way to do this. Instead of saying granted capacity, you could say granted a queue position.
Yeah,
And
work?
Maybe.
that would work for both the pilot and the permanent program.
And you're okay with it?
That works, yeah.
Folks in the back of the room are okay with that?
So we would put it.
Okay. Yeah.
Is it just the one spot in each one? We don't have to change constructed, right?
No, I just think, yep, capacity.
So granted, and this should say now a queue position. Italicize. All right. Does that make everybody happy? Okay, I'll put it in the same place. All right. We're good?
Yes.
Okay. Let me just make a quick note here. Comment for the purposes.
It's so confusing.
Oh, yeah, that's B, C, and D. further down this page, now this, I think we are withdrawing, and there was an agreement to move sort of this issue to this another, the second rulemaking. The issue here is, and I guess, David, you want to talk about your definition that's in your, or no? You have a
I can talk about it, sure.
Okay. Let me, so the issue in question is, the language, basically says if you look at what we just changed, the consensus language, just at the bottom there, it says, subscriber organization may continue to operate, effectively a program was constructed during the pilot or during the program until the community solar energy generating system is decommissioned. And looking at that, we sort of noted, what does that mean? Are we talking about the original installed equipment, or are we talking about a succession of repowered solar facilities for the next, as long as, indefinitely means? So the language here, which we've now, upon listening to what the other folks were concerned about, have withdrawn. I have to look at my notes to see exactly what we were going to do with that. That would basically, and it needed a change to make it effective, would have said, look, if you can't repower it indefinitely. You get the original life of the installed equipment, and if it fails due to an accident or something, you get to replace a portion of it. But once half of it would fail, it's considered to be no longer the original and thus is decommissioned. Folks were uncomfortable with that because it didn't present the certainty they needed to make the investments, et cetera. But at the same time, we think it's very important to make clear that when you get into this program, it is not an indefinite right to sell energy from a solar facility that may be rebuilt multiple times to, back to the utility and, thus to ratepayers, because that might imply a value almost like a franchise to an investor that's saying, hey, do I want to buy one of these things or invest in one? Do I have the use of it until that particular equipment, is its life is used up, or do I have a right that it extends to some point in the future that we don't see? So that was our concern, and I think folks sort of understood what that meant, but they weren't comfortable with this language. So we said, let's pull it back and find a way to address this issue.
Thank you, Chair. This would have been, I think, the most concerning issue for us at the start of this hearing if staff hadn't withdrawn it. I'm not going to go into detail because it has been withdrawn, but as originally proposed, this would have been extremely problematic for developers. The key thing to remember here is with HB 908, the General Assembly directed the Commission to remove what effectively was a 25-year operational limit that had applied to these projects. So that directive's clear, and one of our concerns, among others, with staff's language was it sort of tried to reinsert a similar limit through the definition of decommissioning. Ultimately, this is not a definition of decommissioning. This really is trying to limit the lifespan of a project or deal with what happens at repowering. One thing that we did do, which I think still deserves some consideration, is define decommissioning. And in our comments, we have that definition really tied to what decommissioning is, which is the restoration of a project site to its original condition once the project is done. That can be done either voluntarily, so that scenario is incorporated into CCSA's proposed definition, or pursuant to a county requirement if it's a non-CPCN project, or a CPCN condition. Oftentimes, both at the county level and at the CPCN level, there are requirements that say the project's inactive for a certain amount of time, let's say 12 months, it needs to be decommissioned. So our language would incorporate that. So if the Commission does act on this, defining decommissioning based off of something that actually is decommissioning, we think would make sense. But this, as originally proposed, was problematic, and we're thankful that it has been withdrawn.
So I'm just to be clear, are we? And I agree. I mean, this sounds like forced decommissioning, so it doesn't seem to make any sense.
Yep.
But are you asking, Mr. Auslander? I think you mentioned earlier that you wanted to discuss decommissioning at some point. So are we going to be talking about decommissioning today? Later?
So I
This is
don't.
I don't want to give away, the surprise if you had a surprise.
No, I think that this is the time, and I don't think OPC objects to having this issue discussed further in the work group in phase 2. We do think it's important, though, that the commission make a decision on what decommissioning is going to mean. I think that the 25-year number wasn't completely arbitrary. It was tied to, I guess, some sense of the the average operating life of a solar array. So if that's incorrect and the actual average life is 30 years or 35 years, maybe that's a more appropriate period of time. But I think we do have concerns that I'm assuming that staff shared as far as having the community solar facility operate indefinitely.
Because
I think that that we don't know exactly what the future will hold as far as the technologies that will be available. I think that there's still some concern that OPC has about the net metering rate structure as we approach the 3,000 megawatt cap, and I think there was some discussion, won't the legislature just increase the cap? I mean, they could, but we're at 3,000 megawatts, we're talking about like 20% of the state demand being reflected in net energy metered credits flowing from ratepayers that are not participating, essentially, to provide the credits for the will always be a minority of ratepayers that are actually participating in the program. So we think that the impetus for community solar to increase the pace of solar deployment is an important one. It's in the public interest. OPC supports community solar, but we also think that the incentives that are being built in, the current structure for renewable energy credits, the tax incentives that are currently available, and then this net energy metering treatment should not necessarily be at this point in 2024 deemed to be a right that will.
But I'm not sure that ever happened. I mean, I think you have policies, and policies are constantly changing. People are introducing new ideas. It just seems to me that sort of having an arbitrary sort of endpoint to a technology where you're not really. I don't know what's going to happen in 25 years. That it kind of, on some level, it sort of ties all of our hands. I mean, it may be that these facilities last forever and we don't want them to be decommissioned. Or it may be that every 5 years they come up with a new solar array that becomes, that much more efficient, but then you've got this sort of 25-year period that sort of stops. I'm not sure that it's sort of in anybody's interest to have that kind of arbitrariness about when something ends.
Well, Commissioner, I respectfully disagree. I think it actually frees your hand to have a limit now that could be changed in the future. I think that the danger occurs when a developer is developing a project now that is going to be brought forward in a program that either has language that says it can last indefinitely or does not have explicit language regarding how that access to that rate mechanism will end at some point in the future. And you might run into a situation where at least the developer has an argument that they have this right to continually operate the community solar facility by replacing inverters, replacing panels for an indefinite period of time. And so it seems to me that it would be better to, in 2024, set out some type of definition for decommissioning and not permit in 2024 perpetual participation by these facilities in net energy metering. And I would also like to point out that you wouldn't, by decommissioning the project, what we're really talking about is decommissioning for purposes of net energy metering treatment under the community solar program. It wouldn't necessarily mean that the facility needs to stop operating as a generating system. It just for purposes of this program, we do think that having a start date and some way to determine an end date for a particular project is important and is in the public interest. But we're certainly willing to have that discussion in more detail in a phase 2 of this proceeding.
So, sitting here today, what is the expiration date on the panels?
Well, so I think what Mr. Auslander was mentioning about 25 years, that refers more to what the warranties might be, but not the actual useful life. And I was actually looking at some public resources for this too. That the public from like independent side of things, the perspective of useful life of solar panels could be anywhere 30, 35, 40 years, but it's sort of TBD. A lot of the technology that's being put in today is different than what was put in 30 years ago, and it might last longer. There's been a wave, obviously, over the past 10 years, and so it's a little bit of a TBD about how long they'll actually operate. But generally speaking, I think we're thinking more like 35, 40 years. I think for CCSA, no member of CCSA has said that they're financing the projects based on an assumption that this is going to be repowered indefinitely forever and ever. I don't think any investor would kind of back a project with that sort of assumption. But I do think just based on HB 908 saying these can be operating as long as they're alive, that there is an assumption that 35, 40 years is realistic. We were concerned that, kind of similar to Commissioner Suchman's comments, that this might undermine technology questions. It just sort of raised a lot of questions that could interfere with financing and development that's happening now, and create greater uncertainty for the segment. And there isn't really, frankly, like a good definition of sort of like repowering that's out there. So this is one that we've had a lot of discussion about internally at CCSA. We'll continue that discussion with the working group, but we weren't comfortable with kind of arbitrarily drawing a line right now.
And in my understanding of community solar is to actually provide the benefits of use of that type of energy to low-income customers. So isn't it to their benefit to make these things last longer?
Well, I think that the idea would be that there are going to be programs in the future that are going to be available. I really, and including a new community solar program that might have different facilities participating versus the ones that are participating today. So, as I said, I think our position is that allowing these facilities to operate past the date set out in COMAR is easier actually, and potentially less problematic from a legal standpoint than saying, well, we're not going to say anything now, and then 25 years from now we're going to say, okay, a facility now you need to wind down, you need to stop participating in the community solar pilot. And it seems to me that if the industry, Mr. Cockershaw just mentioned that none of the developers are operating under an assumption that they're going to be operating in perpetuity. So let's just come up with a date that is consistent with the assumptions that that the market is making when it comes to the capital investment needed to construct these facilities.
If I could just respond to that briefly. Again, the legislation directs the commission to remove the 25-year operational limit and allow projects to operate until decommissioned. So logically, if that was a directive, we can't define decommissioning in a way that makes it so there's still a 25-year limit. And again, even if that was on the table, decommissioning, there's no reasonable interpretation of the word decommissioned to mean 25 years. Decommissioning is a process to restore a site to its original condition, often pursuant to either state or local requirements. So we're trying to fit something in here that is not what decommissioning is, and it's just frankly counter to what the statute says.
Hey, John Miller, Chaberton Energy again. I know a lot of this has been said, but I have to underline how important this is to the industry. And I appreciate Phil, and I'm listening to our comments specifically. I appreciate that he decided to remove that definition, but there was a lot of problematic items with it. We need certainty for finance. Esteemed Commissioner Barvet, as a CFO, you understand that. When there's uncertainty, when there's project life, it's highly problematic. I can tell you just the fact that this was added to this document, multiple financiers came to my company to put the halt on financing proceedings we were having. Because all of a sudden, where we had useful life that was an industry accepted basis around that 35 to 40 year time frame, all of a sudden that all had to stop because uncertainty was introduced. So certainty is absolutely necessary. Getting into a little bit of what was said earlier, let's talk about residential rooftop. You don't tell a residential rooftop customer, in 25 years, you got to take this off your roof. So it's kind of a weird juxtaposition to say, but for community solar in 25 years. The concept of 50%, I've never heard of that. I've never heard of, I guess we can call it the Frankenstein amendment, or however it is. But it's not based on anything I've ever seen before. It also what happens if there's an event, a large failure, whether it's due to mechanical or whether it's due to a giant weather catastrophe. We all know climate change is happening, and we don't know what's going to happen here. We're going to be disincentivized when we have to replace our project, even if it's under 25 years. So there's a lot of problematic things going on. We do recommend strongly the PPRP definition of decommission that David had mentioned. It's already well defined. It's in the PPRP. Every county in this state uses it. I've operated in multiple states. Every county, every town in every state does have a version of decommissioning. It's just kind of odd that we're defining decommissioning so vastly different than everywhere else, and it's really problematic specifically for the success of our industry due to that uncertainty that's creeping in. And I can tell you, it's impacting us today. I mean, I'm talking for Chaberton, but I'm sure a lot of other developers are being impacted by this potential decision right now, and just the introduction of this uncertainty has really stopped the market from moving the way that the legislation intended the market to move.
Chairman, Commissioners, Eric Wallace, on behalf of Turning Point, and I'll keep this brief because we've covered this in a fair bit of depth, but I think this was a critical issue that we addressed in our comments. On page 3, I think we kind of laid out the framework of and the points that are important here. And just to reiterate one point that Mr. Bugelman's made, in HB 908, there's a clear directive. We're moving away from the 25-year sunset date under the pilot program regs. We're moving to the statute specifically says that the Commission's permanent program regulations, quote, must remove all sunset dates and authorize community solar energy generating systems, including those constructed during the pilot program, to operate and generate credits until the system is decommissioned. So, I mean, that's crystal clear. And so to go in now in the rulemaking and try to pick a sunset date again, I think is just directly contrary to what the General Assembly contemplated and specified in this clear language in the statute. The one other point that kind of picks up on something that Mr. Miller said is, we include the example here of you could have a 2-megawatt project. You could decide to develop that and bring it online as a aggregate net metering project, no sunset date, right? If you instead take that 2 megawatts and operate it as a community solar project, the proposal here would be, from OPC and to a lesser degree from staff, is that there would be some kind of a trigger point that would force decommissioning before the end of the operational life, as determined by all of the various commercial and practical factors that Mr. Bugelman's mentioned earlier. So we would just encourage the Commission to give clear direction to the work group that we're not going to go start picking dates and put in arbitrary decommissioning points, and we'll follow the language in the statute, and I think that CCSA's proposed decommissioning language is very much in line with that. Thank you.
Just one.
Sure.
One final point. I'm always sort of mindful of opportunities for gaming, and this one in particular. I can see all kinds of gaming opportunities, and 25 years from now, this commission could be very busy trying to figure out, if we reach the 25-year period, or do we suspend the 25-year period when there's a tree fell down on the facility and we had to. So frankly, I don't see the point of it, but I also am very mindful of the potential for gaming. That always makes me nervous.
No questions. Just I hope they come back with the CCSA language.
So, I guess from my standpoint, I view decommissioning as more of a process than a date certain. So, with the utility scale solar projects, there's always that language that's in the list of conditions about all the stuff that's got to be done to put the site back to the way it was, and in my mind, that's the decommissioning process. And I'm a little reluctant to, pick an arbitrary expiration date for this technology, since it does seem to be changing all the time. And quite honestly, what I'll relate it to is when I went through the relicensing of Calvert Cliffs. And, they have, you have to every, was it 20 or 30 years? Yeah, so, there's a time period where you have to go through that process. And apparently when the facility was constructed, it was thought, well, that's when we're going to decommission this plant. And instead, what has happened is it constantly gets relicensed. And the last time I went through the process, which was in 2000, I think, the assessment was, well, this thing could actually run forever until, the containment thing starts to fail. And that's when it becomes too expensive to replace. So I suspect that's true for a lot of these technologies. And so I think we need to, be flexible right now when it comes to trying to pick a date for when these facilities might expire, and instead focus on what needs to be done in order to, when the decision is made, to pull it out of operation and put it back the way it was, as opposed to when that happens. So at this point, I'd say, have the work group go back and sort of focus on that part of it. And if people have, thoughts in mind about a way of determining, an expiration date that makes some logical sense, we'll listen to it, but I don't necessarily want to put it in these regulations today. So.
Yeah, that's why we withdrew this. I think it's something that bears some additional discussion, so we can sort out the policy issue and then bring that back to you.
Okay, fair enough.
All right, I believe our next is on page 33. All right, so before I get to 33, there's a new section here that was required by the HB 908. There was a party that wanted tracking of forest cover relative to these projects. So we're talking about information that, if you look in, I think it's D1, A and B, it's some figures on a project basis to provide the amount of area in acres for different types of classifications, and then to the extent that's going to be changed as a result of development of the project, that has to be provided to the commission. So what we are looking at here is, I think, language that is in this text box where the utility folks had some concerns about how they were being asked to provide it as part of the list in the, I guess, the project queue list. So what we've got is the subscriber organizations are required by the law to give the commission certain information when they apply for projects. That would be like the number of acres that are affected, the forest cover, what's going to be removed, that sort of thing. And I believe we already asked for the information of which county they're constructing in. So what the language, I think, is creating the situation that is a concern to the utilities, and I'll let them get to that. But in section E there, down like right above the text box, it says each electric company shall make the data collected under D of this regulation available to the public on its website on or before January 1 of each year in a format aggregated by each county. So I think we are envisioning that if there's going to be information provided by the SOs, we will incorporate that within our spreadsheet that tracks the subscriber organization's projects, including the county they're located in. We'll have to add however many fields. It doesn't look like there's too many. That will track the amount of forest cover that's being impacted by the projects. That will be provided, if it's not already, to the utility folks, and they will incorporate that within the information that is provided in their project queue. So I believe all that they're asking to be removed is the very last portion that's in the teal colored bracket there, on or before January 1 of each year, in a format aggregated by each county. So I'll let them explain why they want to pull that, but my understanding in the way this is drafted, this is responsive to the way the information is described in the legislation.
So I'll be brief on behalf of the Exelon Utilities. The suggested revision here is simply to make clear that what the electric companies are expecting to do is to take the information that's been collected by the commission and most likely obtained by the utilities from staff and put that on our website. The suggested language, well, rather the consensus language holds the utilities to a date that we have no control over because we're not the one collecting the information. So we thought it would be best to strike that language that holds the utilities to a January 1 deadline, and also suggest that we should provide the information in a particular format. Because again, if we don't get the information by a particular date, we have no assurance of being able to publish that on our website by January 1. And we're simply taking the information in the format that we receive it and put it on our website.
So, obviously, it's the applicants that have to comply with the forest conservation law, correct?
That's correct. And CCSA helped draft the different types of information that need to be reported. I will point out, if you scroll up in the document, this information is initially reported to the commission. My assumption is that would be done on the SO application form.
Okay.
And we're comfortable with that. In terms of where it's published, which I think is required by HB 908, we're agnostic in terms of whether it's the commission or the utilities. It seems to me that having the utilities do it's an additional step, but if that, for whatever reason, is what the commission lands on, we're fine with that. So we're kind of agnostic to this other discussion, but we support the initial reporting obligation.
And from your standpoint, you don't care about putting that on your website. You just don't want to have to do it by a certain date.
That's right.
And is staff fine with that arrangement?
I'm checking to see if, I believe that the date is in there because of something that's in the
Oh, I see. Okay, all right. So while you're looking for that,
I speak representing Potomac Edison. Our suggestion was that it would be most proper for commission staff to place this on their website because they're the ones receiving the data and obviously would be able
so
to.
you're saying it would be on the commission's website, not yours?
Correct.
I see. Okay.
One issue is, especially if it's aggregated by county, for example, there's there's 3 different utilities in Montgomery County, so you would have to look at 3 different sites if you want to know how much it was affecting one county. We have no problem with putting it on our website, but if we do agree with Exelon that it should be we're just passing it along, putting it on our website in the same format.
I take it Delmarva doesn't, because Delmarva's got a worse problem than he's got when it comes to counties.
Precisely, and I should have been clear. I'm speaking on behalf of Delmarva as well, the Exelon Utilities.
So Delmarva is fine doing this as long as they're not required to do it by a certain date.
That's right.
Okay.
And again, to be clear, we're simply taking the data in the format that the commission provides it.
Sure.
Yeah, Mr. Chairman, I'm looking at the bill right now of the enrolled law, so I'm not finding where the law requires that date. Am I right? I mean, somebody who's read this more carefully, I don't think it's required. I don't think that date is required by law, is it? I'm not seeing it.
So, Mr. Michelle, you are literally just taking whatever they give you, and you would just turn around and put it on your website.
That's right.
So that seems like an extra step.
To the extent that the commission finds it helpful,
I appreciate that, and so, Mr. Vanderhayden, where would it be on our site? If we had the data, staff has the data, where would you publish it on our site? There would just be a link to.
I would probably have to speak with Mr. Mars Wu, as to say, here's what we've got, and here's where should we put it.
Well, actually, for the utilities, where would you put it?
Presuming, we talked earlier about how we have a queue that is maintained on our website. We do that now during the pilot. We will continue, based on this proceeding, to do that at least at the beginning of the program. We would assume that we would add a section or perhaps a page onto that if we did it ourselves. But yeah, I do agree it would be an extra step we'd be taking that.
No, I understand. I take it we don't have a community solar page or whatever? Or?
We, there's a landing page for it. We don't currently post the projects there. That's on we refer to the utilities community solar website for folks to get the list. And then MEA has a list of all the projects on their website.
And what the Exelon utilities would likely do is simply take the link to the commission's website and stick it on a page on our website.
Right.
Yeah, it's,
Well, it seems to me if no one seems to have been able to find this date, maybe it doesn't exist. So,
Yeah, I mean, there's a, I don't know where it is in the, so, I mean, I think we originally proposed is that each project would come in and there would be apparently a field for existing forest cover and, how many acres. And, we have a spreadsheet that tracks each SO's project and they're sort of listed on a row and then they go all the way across. We would need to add a couple additional fields. I think we would presume, I think somebody mentioned already, we'll take the application and add fields for each project, or maybe we'll have to come up with a way so that there's like a minimal amount of data entry on the way in. So probably we'll add it to the spreadsheet. And so I think what we were proposing is that we would provide the additional information, so the county of the project, if that's not already provided, and the various metrics for forest cover, and that the utilities would, they'd have that the way they display the project now with its size and address and name and SO number and that sort of thing, and there would be a couple extra fields that they would have to display. That's what we thought would be the simplest, most straightforward way to do it. And then that list would have to be sorted by county so that you could see, how you would do that. If the commission desires, we can certainly do that here. It's just a matter of, I didn't want to take on additional obligations without figuring out how that would be done, and there'll be an economic impact statement for these things. We'll have to figure out number of work hours to do that and that sort of thing. So.
I guess you sort of have to ask why. What's the value of the data? And to the extent that you're interested in impact on forest cover, you'd think that actually it would make sense to have the data be aggregated by county and by state, and the best source for that would be us. I mean, why else would you have the data? I mean, when you have data requirements and you just meet the requirements without thinking about why, then you lose the value of the data that's being provided.
I can tell you why.
yeah.
I mean, this has been a big point of contention between the solar energy industry and the forest conservation folks. And I imagine, actually, I'm not so opposed to putting it in on January 1st because the legislature meets on the second Wednesday of January. I mean, I'm not saying, I can't find in the law where it's required to, where a January 1st reporting requirement is, but I mean, I could easily have imagined us putting it in legislation for precisely that reason. So
Well, and I guess, I agree with Commissioner Barbie that, the forest conservation is a hot topic for a number of entities. So there are people that are very, very interested in this information. So maybe, given that, it probably ought to go on our website. If you guys want to put it on yours, for your own purposes, I suspect that's fine. But as to make sure that it shows up somewhere, and then if somebody asks me where is it, I can say, hey, go here and take a look at it. We should probably put it on ours. I don't know. Again, if there's no date in there, I guess I don't necessarily want to tie us to a specific date, if we don't have to. So
no, I mean, but when we pass the update of the Forest Conservation Act, one of the first questions I asked the conservation advocates, I mean, this siting of solar and of transmission corridors, they wanted to just take away from utilities the ability to do that, and I wasn't going to tolerate that because we need more transmission corridors. So the point I'm trying to make here is it was quite integral to the legislative intent to make sure that we balance those issues.
I agree. So,
Right, so it seems to me that the last thing we want to do is disaggregate the data.
right, yeah.
'Cause-
So we'll have it on our site for sure, and if you guys want to do it for your own purposes, that's fine, but.
So in that case, Chair Hoover, based on that, I think we should either remove E or change shall to may. I think it'd be easier just to remove it,
Yeah.
but
Yeah, I guess, I mean, you're just concerned with what you guys have to report wherever you got to report it. So I
That's
guess
exactly right. Again, we're fine with that. I will point out the legislation does say that the commission has to make the data collected with respect to the forest cover information available to the public in a format aggregated by county. So I think, again, that suggests it needs to be on the utility website.
wait.
Excuse me, the PSC website.
Right.
Yeah.
And, in terms of whether that needs to be in the regs or not, we're fine either way. I mean, obviously, the commission doesn't like directives. We just had that discussion,
Sure,
so
sure, yeah.
we're fine either way.
So I guess we can just delete it then. So.
All right, so we will get rid of E in its entirety.
Yeah.
Let me just check to make sure. Actually, I guess I can take all of that. And if I could, I think going up to D, just as this is not going to change the meaning of this, but it says the forms authorized by the commission under A shall require a subscriber to provide the following data. I'd like to make that active, where a subscriber organization shall provide the following data on forms authorized by the commission. Is that okay?
That's fine.
Okay.
So I'm just going to note to make that passive, or active rather. All right. Getting back to our list. All right, page 34. All right. This is part of the global queue issue, correct?
correct. Yeah, we can move past this one.
All right, so we are not adopting this language. And 36 is, all right, so I believe this is, let me check to make sure we didn't make an edit to this, but this is now agreed to be
Yeah, I think.
consensus language.
Yeah.
Yeah, I have no note of any edits to it, but everything in green is consensus. And what this is doing is, I think, capturing the changes that the commission already has made to the process for approving multifamily dwellings as low-income accounts. This is all accepted. All right, 37, 38, and 39 may be part of the global. Let me check to make sure.
No, this one is LMI.
So here's this page 37.
The LMI, sir.
Yeah. I think that's a discrete issue, Phil.
Let me check. Okay, right. Okay, all right, so this is the issue where we've got a requirement to have the customer list that a subscriber organization is, or a subscription coordinator in this case, is providing to the electric company for the use of allocating the output of the CSEG to each account. And the way the language above it indicates, and we're just, I think all it's happening there, it's renumbering and adding the subscription coordinator, which is the new participant that we license or we authorize to work with the subscriber organization. It leaves the language in place that is a certification that is provided to the electric company that the SO or the SC has verified, so past tense, has already verified the eligibility of the LMI subscribers. And I think we are happy with that and believe it is a correct part of the process, whereby once that list has been fully subscribed or partially subscribed, however it happens to be, that is a verification is done by the SO, and then they provide in writing, we have in fact verified that these this customer list qualifies as LMI as needed. That'll be sort of important now that like all projects will have a 40%. And I'll let the utility folks explain what they would like to do that's different here.
Sure. So this was a very hot topic for us, and I hope the commission can appreciate why. So there is a concern that the utilities are being asked to regulate and police subscriber organizations. When you think about the purpose of the LMI attestation, right? I think earlier OPC mentioned an interest in LMI-related issues. I believe Chair Hoover and Commissioner Suchman also mentioned the need for OPC to have certain information and data related to LMI. The attestation that's being provided here has no use to the utilities, right? The utilities don't have the ability to audit the SOs or, reprimand them if either they don't provide that attestation or they provide an attestation and the facts are that they have not met the LMI requirements. So for those reasons, we think that as proposed in this suggested edit, the commission, who has the ability to reprimand or take action, investigate, audit the SOs, the commission should receive those attestations, because once the utility gets them, we can't do anything with them. And then I had an epiphany last night as I was reading OPC's comments on this proceeding about the need for certain information and data. If there's any entity that's best suited to use this information, it's OPC. So if the commission is not interested in having those attestations made to the commission, then maybe OPC would be the entity to receive those attestations, as Mr. Auslander mentioned this morning and in his comments, that OPC by statute has the ability to conduct investigations into issues that affect residential ratepayers. But certainly, of the three options, the utilities should not be the ones to receive those attestations.
Thank you, Chair. CCSA supports continuing the current practice, which is to provide these attestations to the electric companies. And our primary reason for that position, it's really an operational concern. The way that it works is these are provided right at the PTO stage, the permission to operate stage. So the project's constructed, it's ready to energize, and the way it works now is the utilities are the central place where that information goes. It's provided the project can energize. In terms of the value of it going to the commission, every single project under the permanent program will need to be 40% LMI. The attestations are useful mechanism to have in place for projects to think, have we met it? It's almost a reminder. But the fact is that every project has that obligation, and they could be subject to audit by the commission at any time for compliance with that obligation. So in terms of serving it as a check on projects and having that in writing, it still serves the same purpose if it goes to the utilities as if it went to the commission. And we're concerned if it went to the commission that it's just an additional step, which at this critical point, which is, can we turn this thing on, it could create bottlenecks and further issues with paperwork.
Okay. Actually, so who are you and what's on your mind?
Of course, yeah, thank you. I'm James Feinstein with Arcadia, a registered subscription
Okay.
coordinator in Maryland, the largest subscription coordinator in the state. So our concern with this, we understand, we are glad, Maryland, we fought for the 40% low income or LMI requirement for projects, and we fully expect projects will absolutely get there. Our only concern is mandating that for a project to energize, they must have already met that 40% requirement, because in not every instance will that be possible. So I think some kind of like grace period, whether it's like within 6 months of PTO or something like that, will give substantial flexibility to the project. We already see this today in a number of states where it's very hard for projects to predict the exact day they energize, and it can take up to a year to acquire customers. And if a existing subscription coordinator fails to perform and another one has to kind of swoop in at the last minute, they're not going to be able to get that project to 100% immediately, and that will lead to projects having to delay when they energize or when they have that permission to operate, because there may be 35% LMI subscribed and they'll get to 40%, but they just need a little more leeway. And I don't think it's in anyone's interest in this room to have those projects delayed if they don't need to like that.
So, Chair, if I could just clarify what I'm a little thrown off by what we're addressing in terms of the suggested revisions that the Exelon utilities are proposing. Note that our highlights do not address anything about when these attestations would be made. That's already in consensus language. We're just focusing on who receives those attestations.
Okay, and just so I can clarify this, I mean, if, as was explained by Mr. Bugelmans, if this is like one of the on the checklist of stuff before they get the authorization to turn the thing on, if that's provided to you, if you have no requirement to verify the accuracy of that, do you have a problem with them just providing it to you as part of the process to turn the thing on? Because I think there's two different issues here. I understand that because there's a whole series of things that has to go through engineering and things like that before you say, flip the switch. So if this is just one of those things that you just say, yeah, we've got that, but you're not responsible for verifying that the accuracy of it, then that should take care of one of your concerns, correct?
Yes, absolutely. Should take care of one of our concerns. But then that begs the question, what's the purpose of the attestation? I mean, Mr. Bugman mentioned that all these projects are required now to meet certain deadlines, and he suggests that they will. If that's the case, then what's the purpose of having these developers attest to the fact that they've met it? So,
all right. Well, I do think there's a separate issue about, and again, it gets to the issue that was raised earlier about gaming. Because I remember when this statute was being considered, the OPC, amongst others, had some concerns about, how are we going to verify that, this actually is meeting the 40%. And I guess there really wasn't a decision made by the General Assembly about who's going to be the cop. And so the question is that us? Is that, them or somebody else? But I guess the other thing that I'm a little concerned about, this idea of if giving some time period to hit the 40%. I mean, I guess my understanding of the legislation was you had to have the 40% in hand before you did all these other things.
Yeah,
Opposed to,
Yeah, that's
getting
right,
it
Mr.
somewhere down the road.
That's right, Mr. Chairman. I don't see any reference to a grace
And
period.
so I guess, is this,
Yeah, I'd have to go back and look at statute, but I know this. We discussed this at least one net meeting, working group meeting.
I mean, was it contemplated that this?
I was whispering with Mr.
Yeah.
Kogoshaw about this. Our current position is we support the language that's on the screen, and that requires a verification that you've met the minimums at prior to PTO effectively. The idea of a grace period, we think that could potentially warrant some further discussion if it really is an issue, especially with these subscription coordinators. But that hasn't been discussed at length with the work group. So I hate to say it, it could be another issue that could be kicked back if the commission thinks there's merit to that discussion. But we support what's.
Well, I guess my first question is, do we even have the ability to do that? It's one thing to consider it as an idea.
Right.
It's something else. Is it within our authority as given to us by this law to do something like that, or was it contemplated that, look, you got to have the customers in hand before you do everything else?
Yeah, and I'll just echo Mr. Bugelman's, which is for CCSA, that we support adopting what is up there now. We would also support adding this to the working group, phase 2 consideration of looking what's in the statute, seeing if that makes sense or not. But it wasn't something that was substantially talked about in the working group to date, so we're good with what's up there.
And I assume you're not interested in being the LMI policeman, correct?
Well, I mean, I think OPC would certainly, not object to getting the information. It's just, it seems to me that it should go to either the electric company or the Public Service Commission.
See, and that's the problem I have, is that the language as it's drafted, you use the word certify, and certify suggests an active role. And so I'm a little confused then about, so this PTO process, what do you think you need to be able to demonstrate to the utility or what do you think the utility is going to want to get from you?
So this is something that exists under the pilot. So we're recommending continue the practice. My understanding is it's a form. It may be under penalty of perjury that says we have met the minimum.
But can it just be, you go to the utility and say, we've met all of the conditions?
Yeah.
And Mr. Michelle, I agree with you. I mean, we can't put on, at least personally, I don't see how we can make you be the SO cop. I mean, that's just,
right.
And I'm not sure that anybody really wants that because it doesn't make any sense. And I guess the question is a process question. When you're ready to go to the utility for PTO, the utility, Mr. Michelle, what do you think you're going to want? What are you going to ask? Have you met all of the conditions? I mean, that's kind of
right. In terms of, there is an established process for what's required for PTO. It's not as if the utilities are asking for any additional information. In fact, we're asking for the opposite. So I don't think that's in question. This attestation, as Mr. Buchman mentioned, is a rollover from the pilot program, and frankly, we don't do anything with it because we can't.
I mean, maybe this is a vestige from an earlier time. I guess if the utility doesn't need it, and you don't need to provide it, then maybe we don't need this at all.
I think that is a good point, Your Honor. For instance, when you apply for SO approval, you have to submit an affidavit of general compliance where the project says I'm going to comply with all program rules. Even without that, the program rules apply. Mm-hmm. As I said at the beginning of this, I still think there may be some merit to this as a check, almost a reminder, and it's a piece of paper. If there's an issue later down the road, the commission could say, you certified this and it was wrong. And so maybe there's something there that's useful.
Well, I think the answer is you shouldn't have gone to the utility and said we're ready.
Right.
I mean, so I think the onus is on you to make sure that you've sort of complied with all of the requirements.
I completely agree with that. So if the idea is to remove this, that's also fine. Again, our number one concern with this was just creating another step at PTO hold projects up.
Well, and also
because of
create
paperwork.
create a new responsibility. I mean, so then we end up with a responsibility. The utility ends up with a responsibility. Maybe even OPC ends up with a responsibility, and that's too many responsibilities.
Yeah. I'll just briefly add here that the statute, HB 908, called out subscriber organizations, subscription coordinators shall verify the eligibility of an LMI subscriber in accordance with that subsection of self-attestation and retain records of each determination of eligibility for an LMI subscriber to be made available to the commission upon request.
Yeah.
Right.
So, like to Mr. Bugman's point previously, there could be an audit at some point. There could be some sort of tracking at some point, but the onus is on the subscriber organization, subscription
Yeah.
coordinator.
Okay. That's what it says in the law.
So, what do we change and move forward on this? Because it sounds like conceptually we're in agreement, but
So this, currently, what happens is a letter is provided, almost like, here's your electrical inspection. We are verifying in writing that we have, in fact, done the verification.
Right.
And so that is kept by the utility. And at some point in the future, if there was a need to sort of, audit those, are they all there? Or if there was some concern, we could at least check to see it. Well, when they filed, it was verified, and then 5 years later, we find out that the lists are no longer accurate or something. So, I think I would recommend leaving it in place. And if folks want to talk about this process of altering how we're taking these things on, we can certainly look at that. But this,
You want to leave this language?
I would
in
leave
place?
the language unchanged. I mean, we have to add subscription coordinator because they're
But the
involved.
problem with leaving the language in place is it sort of flies against the discussion we just had, which is that it's incredibly confusing
Well,
and imposes an obligation on a utility that doesn't seem to
Right.
make any
So-
sense.
So we need them to keep that record because.
well, I understand,
we-
but I think there's a difference. See, right now these words shall certify. In my mind, I think in some other people's minds, creates this idea that the utility needs to do something with that other than just hold on to the list of things. So what you're talking about is, they get it and they just keep it, and then at some
Right.
point down the road you want to see it, they give it to you. But in order to convey that requirement, I think we need to reword this to make, what they're doing, more recognizable of that thing, as opposed to, what's implied in this current language, that they actually have some role in verifying the accuracy of the data.
We could add, something to this that says, the utility has no obligation to, check that the verification has occurred. It's just that they are responsible for obtaining, what is essentially written verification. Someone from the company, someone from the SO is writing down that, yes, we verified that this list, meets the standard. Otherwise, I'm kind of wondering where that would occur. And then, we were talking about earlier about gaming of situations.
Well, but I mean, look, the law requires the SO to do all this and retain the records for inspection by us, the PSC. I mean, the law itself doesn't mention utilities.
Well,
Yeah, I don't think that this makes. I think this just creates confusion. I don't think it. I mean, it doesn't seem to add anything to the process. I mean,
Right.
they're gonna be doing their SO, and they're gonna have data that's gonna demonstrate that they meet the LMI requirements. And then they go to the utility and say we're ready to go. And
Is it better if the commission, as part of that process of turning it on, gets that verification, or are we talking about no one actually has to? The SO is no longer obligated to verify.
don't they
write
have
down-
to? But don't they have to verify that to us?
Well, no. Right now, the verification is provided and kept by the utility. What I'm saying is, I think what's being proposed by the alternative language.
So I'm confused. How are we going to know that the SO has met the LMI requirements?
Commissioner, the statute requires SOs to retain records of the verification of each subscriber and then provide those records to the commission upon request.
Okay.
So it could be requested at any time, and if that's not provided, that's a problem. So I think that's a very strong mechanism to certify compliance.
And you're required, and the SOs are required under the law to verify the eligibility of the subscribers, LMI subscribers.
And you're going to verify that to us? Oh, you'll just verify that?
They'll verify
The
it.
project's verified, because it is a lot. I mean, there's hundreds, I mean, it's a lot of customers.
Right.
But if the commission requests it, it needs to be provided.
Okay.
Yeah.
And based on that, Chair, I would suggest that we just simply delete this provision.
That makes sense to me.
Okay, that's fine, but do we need to add a new section saying that they need to send it to you, or?
Well, I suppose without any language at all, it's not clear that there's ever a risk of,
Sure.
turning the system on and then not actually serving the required low-income customers. Which is why I was suggesting we leave it alone and figure it out. Like, how do we want to do this?
Well, the statute has the language itself that says that the commission has the ability to essentially audit, and that the SOs have the obligation to verify and do all of that. I think we all seem to come to an agreement that there doesn't need to be a paper document where the SOs are providing some attestation either to the utility or the commission, but the commission retains that right. Whether we put that language again in these regulations, it doesn't really add anything in terms of the commission's authority to request that attestation.
I mean, we could put the language from the law in.
That would be easy as well, copy and paste.
That's all right with you, or?
That's fine with us. We could cross-reference the statute or just copy and paste it.
All right, so we'll do that. So take the language out of the statute that the requirement is on the subscriber organization to have such a list and it be available to us for inspection, but they don't necessarily have to send anything to anybody, either them or you.
So for the purposes of today, do you want this out?
Yeah.
And then when we would add the additional language at some point in the future? I'm wondering, are we going to be able to adopt something today? And
I think we can. I mean, if the commission has just ruled that we take the language from the statute and put it into the regs, I think that's decided.
All right.
Okay, well, I need to.
But I guess I have some concerns about, like writing on the fly regulations. So is this a little beyond the technical things that we do to?
How about
Okay.
How about copying and?
No, I understand, but yeah,
the fly.
so
That's just guidance.
yeah, so all right, so we'll provide guidance, more specific guidance on how we want you to
With a
rework
scissor.
this, and then that'll be incorporated into the new regulations. So
Got it. Okay, so I'm going to strike all this out,
yes.
and
And
the
we'll just
new
add
language.
a reference to the language that's in the authorizing statute for the community solar program, that the subscriber organization has to go through the process they have to go through and have those records available for us, should we want to look at
At our
it.
request, yeah. It's at the top of page 16 of the enrolled law.
It's section L1,
Yeah,
Romanet 2.
yeah.
So can you give me that again, please?
L1, Romanet 2.
L1, little I.
Yeah, we're 2-2.
Let me,
So you see it?
yeah, you have it.
Yeah, it's right there. I think the retain records is this one too.
Okay. All right, so we'll draft something up that sort of turns that into regulation and then add it to this.
Okay.
All right. So that was page 37 and 38. All right, is this again referencing sort of the Q-ish language?
Yes, that's
So we
Q
are
language. Yep.
leaving everything alone and not adopting what's in the box here on page 37. how about page 38, sorry, 39? Sorry,
That
we
one
just-
as well.
We just changed 38. We're now looking at 39.
That one as well.
Looking from the nod from the bench.
No, yeah, go ahead.
Good. All right. All right. So bottom of page 39. Let me check here. I think we. So my notes from our call last week was that folks were okay with this, with the exception that it interferes with the global Q language. So are we leaving the green language in, based on what we did last week?
CCSA supports this. I think we wrote it, although it's passive voice, which I think it maybe should say in order for the electric company to deem the application complete. But the idea is that the partially executed interconnection agreement, the proof of site control, and the proof of application for permits, those are the three things you need for a complete application. Just trying to clarify that that's what this provision is talking about.
So is the utility going to actually deem it complete?
Yes.
As opposed to sort of saying something, an application shall be complete when the following.
It is the electric company deeming it complete, and it's important because as soon as it's deemed complete, that's when the 24 months start to run.
Okay.
That can be extended to 36.
Okay.
Should we?
And is that made clearer in the rest of the regulations? This deeming
Yes.
complete.
I think so.
Okay.
Are you recommending adding in order for the application to be deemed complete by an electric company?
I think it should probably be in order for the electric company to deem the application complete.
Okay.
Because it's just passive voice.
Yep. No.
You're all right with that?
I hesitate to say yes because we prefer this to be
I
done away
mean,
with. But
the
for
larger-
today's
some
purposes,
Specifics of this sort of
yes,
language.
comfortable with that.
See, that's the whole point, is that we wear you down. So
think we're
so
getting to
for
that
the next
point.
hour, we're going to get everything done.
All right.
Hi, John Miller from Chaburn again. Regarding this point, not specific on what you're talking about, I just want to put down that it's necessary for clarification that the requirements laid out here are full and everything. As a developer, we've had multiple instances in the pilot program submitting to utilities where it hasn't been exactly clear what's been required. The requirements have changed even inside utilities where documents we've submitted in the past, all of a sudden they needed more. So I don't really have any specific suggested changes other than just clarifying that what's laid out here, it's in black and white, and that whoever ends up being the party that received this application, whether it be the utility as laid out here, or however it may end up for further conversation with this gentleman, that it be a black and white application requirement,
so-
and there's no flexibility.
So usually when it's the include but not limited to is when you get into trouble. So I think if you have, if you've met these conditions, it's deemed complete. I think that should be okay.
Okay, yeah, I think this was very similar to the pilot, and we had a lot of those issues, particularly later on into the pilot, where we would submit the same documents we submitted a year ago, and the utility was like, no, now I need this. So I'm just raising that concern as something that has happened on the ground, but no specific changes I'm requesting here.
Mr. Vanderhayden, I think you're missing complete. You've crossed it out when it
All
shouldn't
right.
be.
I'm reading it. In order for the electric company to deem the application complete, right? And I took out deemed, there we go. And then deemed goes away.
I need to hit the mouse room. Is that going to be a problem?
Well, I was going to sort of take a time out at 4 o'clock. So.
In order for the electric company to deem the application complete, right? And I take out this. Everybody happy with that?
Yep.
Good? Okay. We're getting down to the end of the list. Which is kind of like,
Well,
that's
so
a fair, go ahead.
that actually that brings up a point though. Since we are at 4 o'clock, Do you have an idea of how much more we have to do if we complete today, and can we get it done today, or do we need to come back another time?
So of the changes, 6 of them are marked. I think might be relating to the global, and then 2 of them are the OPC issue you talked about with the data. So that leaves, I think, about a half dozen, and some of that is just cleanup. So I think I would give it another hour, and we should be done. I think.
All right. So with that, why don't we take like a 5-minute break right now, and then we'll come back at 4:05 and look to be down around 5. So.
All right, back. The Potomac Edison National Meeting. Don't you guys have to get back to the
Yeah, I didn't do something. Exactly, yeah. It's not here, Roger. Hey, I'm glad we got there in the online.
So, as far as you're concerned, are you finished with the Easton settlement?
Yeah. Yeah. Yeah, it's one of those like yeah, especially but then it's like it is funny because like
It says it's similar, but it's not. Say like
right, yeah, if we keep the requirement for yes, we can just delete these ones. Yeah, it's not just requires that you have to do it. Yeah, require you cannot break the law. But it's a process.
I'm wondering just.
I guess it's a little weirder than
that layer
out
to this.
Yeah, it's the same. You can change subscribers.
I mean, it says.
Yeah, now you could apply. If you could apply day one, and you set it, and then 1, 2, you remove all those. Yeah, or.
Oh yeah. Yeah, John Miller. Yeah, Mike Doniger mentions you all the time.
Right.
Mike John Nesda. I'm the other John. Yeah, John Nesda. I call him Evil John. He's taller than me. He has a goatee, so I naturally call him Evil John. Oh yeah. Yeah, I think I saw you at the Solar Focus event as well. Yes, this is the second time we got a chance to meet you.
Yeah. Okay. I thought we met.
Yeah. Oh, wonderful. Oh yeah. So he lives in Montgomery County. Yeah. So he's our CEO founder. So he lives down by Kensington. So he started us, and we're in Rockville now.
I think what we should say.
Yeah, I know we're working with you. We have a couple battery things that we're getting ready to send your way. Particularly over the area where we have a couple projects. The one in Howard County, that road there. We're starting to explore.
So you're thinking that would be like a flexible here?
That's where we're kind of looking right now. I mean, we actually just talked about it. We're in the middle of our company weeks. So we just talked about it Monday, and we're still figuring exactly how to make it work. And we're looking at all these things. But right now we're thinking flexible. We were thinking about how can we do it. One of the other things we're thinking about how much battery capacity, solar capacity. Is it something where we can do like we can put it on the grid when you want it, like to help even it out, right? Because you already have 50+% there, so maybe we can make it so we can cover the extra. So we're doing that. We're actually, I think, had a conversation with a battery storage company just about the feasibility of essentially uploading during the day and offloading at night. Because as you know, batteries, just like your phone, they operate most efficiently in that 20 to 80 range. So you never want to fully deplete. So
I want to talk about that more.
Yeah.
We're looking for a reference to a first project
Yeah.
to do
That's wonderful.
connection. I think
Oh, that'd be wonderful. Yeah, we're super jazzed about that. Now, of course, the recent news that battery storage parts are going to have tariffs on them for China have made things a little more difficult. But yeah, the EV stuff, and I think battery storage is up to 25. It was 7, now it's 25. So, of course, while we have these goals, we keep making it also more expensive to meet our goals. That's the funny thing with the execution folks and then the policy folks. Yeah, no, we're super excited about it. And I know they've been involved in the energy storage working group. So I was in New York, and New York actually has a burgeoning storage-only market. And I'm trying to learn. Which is directly who
Well, the interesting thing is we've been doing, all of the hybrids we do are genetically modified. So we've been doing genetically modified.
I'm going to take all the good stuff from all the other markets. Great place. Because I like Maryland. It's a great place. It's a great place to do business.
They may.
All right.
Well,
So,
yeah.
I love
No, I love
No, an hour is not.
Yeah.
An hour is an hour. 5 minutes is a
Yeah, that's true. Yeah.
Never went through
Light at the end of the tunnel.
pilot program for essentially virtual DTT control that was done via radio signal. I'm trying to do it on one of my projects. I love. There's always a way to do it. So I love to explore more.
We go in another hour and actually help. The ball game just ended apparently.
Oh.
There's more utility folks that just thank you. Yeah.
It only references
Makes sense to you.
Yeah, yeah.
An hour left.
There's a lot going on.
Right. Yeah, I think we're actually pretty close.
Right.
That's good.
They're gonna,
Yeah, we want to get it right.
All right, so there was a game this afternoon?
Yes.
Oh, yeah, we don't want to be, like, right now anyway.
Yeah, so they're probably leaving right now. So.
Yeah.
Did they lose?
No, actually, they won apparently. So.
Oh, okay. That was a really bad attitude on my part to lose. But I'm not even a master.
all right, so please just completion.
Mets fan?
I grew up as a Mets fan,
Yeah.
but only because my grandfather was a Mets fan, and he hated the Yankees, so that I hated the Yankees.
Was he a Dodger fan? Or?
No, well, he
Or a
was.
Giant fan?
No.
everybody can take their seats, we can get back on the path, so.
All right, so we just finished up on page 39, and the next edit, I believe, is 40 and 41. All right, so the alternative language here is to actually delete all of C, and let me make sure. C is the operational deadline regulation.
Oh, yeah, okay.
So I think this is part of our
This is design, yep.
do this later.
Okay.
All right, so we are not doing that. And then we go to 42. I think this is just a correction. All right, so under D, project website information, I think we have two different versions of this, but I'll let the utility folks tell me if their version of D goes along with the global issue with the Q, which I think it does. All we're doing here is fixing some language. So in D, well, this is the fix is in D3, but the language in D, this is saying that the removing provided daily updated information, which with language that's basically specifying that within 1 business day of accepting a new application or revision, but no less frequently than once per week, the electric company shall update providing a publicly accessible location on its website current status about the removing pilot program queue, and then the following information.
Okay, so that doesn't make any sense to me. If you have a shall within 1 business day, then that is a requirement. But no less frequently than once per week. So then that's not a requirement.
So if they don't update, they still have to make a change to. They have to basically say
No, but you have a shall. I mean, you're not saying the electric utility shall to the best of their ability. I mean, it's either
Well, I think it's adding a second requirement. In other words, if there is not a acceptance of a new application or a revision of an existing application, they still have to update the information once per week. So it's maybe not formed as great as it could be, but what it's saying
it's just not clear.
Okay.
I mean, that's.
I think this language was placed here by sort of a joint modification. So I don't know if your folks have something else you wanted here, but what we were trying to do, from my understanding, is it was a daily update before, and so I think the utility folks are saying, well, we don't want to do this on a daily basis. So it says, all right, well, within a business day of a change, but whereas before you had daily, now you're going to, update it at least once a week. And I think that if there's no changes to it, it might simply be, a new date on it. So there haven't been any changes, and not that it simply wasn't updated. I think that's they were trying to achieve.
Right. I think you need to
Okay.
play with the language a little bit, because it's really not clear at all.
I agree. It's not clear. I think the dynamic with this information is there's updates when there's a new project that's been accepted, but there's also updates that just happen when a project's after it's been accepted, like if it drops out of the queue, and that's also useful information.
Right. Then those are two sentences.
Exactly.
So one deals with one,
Right.
one deals with the other.
So who uses this information?
Developers, for a variety of reasons. When you're planning projects, even financing to confirm, it's a project with a queue position.
So given that, maybe you should pitch what it is you think you need and when you think you need it, and then find out from the utilities if that's an impossible burden. So maybe that's the way to fix this. So
We go back to the original language. It just says they provide a daily update.
But I thought the idea was lessen the burden or what. I mean, it's doing this daily update process,
Yeah, so it's It's the daily language that we would much rather change to the once per week.
Okay.
So if
So if
that's
we
okay with
struck
you guys-
out within one business day, we just say, once a week. I mean, does that work for you guys or?
We're fine with everything once per week, as long as it's done
Yeah.
once per week.
Yeah, okay. So can we amend this to eliminate the daily requirement, but keep the once a week requirement? And we can keep the word shall, I guess, so.
So if we just pull out within one business day of acceptance up
Yeah,
to the
right.
but.
And the but no less frequently than what's, so to just say shall, provide information at least once per week, so.
Well, I could rephrase it that way. Now it reads, electric companies shall no less frequently than once per week provide, I guess it needs,
No,
it said
Yeah.
update in a public accessible
yeah,
location, so it's information about its
So-
current status.
Yeah, I think we need to keep the language about a new application or revision.
Okay.
Because
Yeah,
otherwise,
no,
if there is,
if
there's no,
that's fine. Yeah.
yeah.
So
Yep.
keep what it is that you're providing and when it is you're providing it.
Agreed.
But just eliminate having to do it once a day, so to speak. Okay.
All right, so we'll make edits to this.
Yeah.
Basically.
Yeah.
So we're going to leave the once per week or within a business day, and then we need to fix it so it's clear as to within a business day of a change and otherwise once per week. Is that
No,
I think
no.
we're getting rid of the within a business day. What they said was they need this information at least once a week. So that's the requirement.
Oh.
Yeah,
The
I
information
would say
change-
it's whenever there's a change, that could be
Yeah.
a new project added or a change to a project that was in the queue.
right.
Every time there's a change, once per week.
Once
there
per
should-
week it
there
has
should
to be
an update.
done.
Can you just have whenever there's a change to a
Right.
project? Does it have to be, do you want to
Is
spell
that
out what that
specific
change
enough,
is?
or-
I think the language there does it. It says, and
So you're okay.
whenever there's a new application or revision of an existing application.
Right.
Okay.
I think
So-
that's fair.
Okay,
Yep.
so that works for you.
Yeah.
Now,
Yep.
Are we taking out the no less frequently than once per week? then?
Yeah, that's so we're taking out that part, but
Yeah, you want to take out the daily also.
Sorry, not to throw another wrench in this, but I think it would be helpful to us to understand now that the pilot program is over and there's no capacity limit to worry about, exactly what information in here is beneficial to the solar community. Like, why are we doing this every week? Why do you need it?
It's still useful to know where projects are located because you can roughly estimate if there's potentially going to be a major issue related to interconnection. It's also very important for project financing because having a valid position in the program, that's what makes or break a project. And the utility queues really are the official list that we use to verify that. So it's actually extremely important for this to be up to date. And I've seen it impact deals, like projects are waiting to be financed and the list is out of date and it's a huge problem. So it's important even without the limited capacity.
And I just note for the Exelon utilities, this was an item that was linked to our discussion for removal of the queue.
Right.
So we might come back.
yeah,
to
I understand. So we're just going to deal with what it is right this moment and the global thing changed. So you understand why they what they
Yeah.
need and why they want it.
Mr. Michelle's caveat that we might want to come back.
Yeah, no, I understand.
Yep.
So,
Okay.
yeah.
Thanks.
Okay.
All right, so the language in D is.
So
edited.
it's actually, I think you're striking the wrong thing, but why don't you just have within 1 week of acceptance, so an electric company shall within 1 week of acceptance of, so you have to do it within that week.
So take out business day, replace with week.
Yeah.
So, in my mind, it should be. I think maybe the issue with that would be it sort of makes it on a rolling basis.
Right.
So if there's an update, let's say on a Monday,
All
it
right,
would need
well-
to be updated by the following Monday.
Right.
So it needs to just be once per actual.
I understand. So here's my suggestion. After we get done with this, the developers, utilities, and staff get together and work out the precise language that you want that gives you what it is you need to know, when you need to know it, that's not too burdensome on them providing it. So, as opposed to us kind of doing it on the fly here, so.
So the conditions will be the same,
Right,
basically.
yeah, the information is the same, and the only change is it's going to be provided once a week, but it will be provided once a week in line with what they think they need. So.
Okay, so if no changes occurs in a week, it's not updated.
yeah.
If a change occurs that week, it has to just, if it occurs on Monday, it has to be done by Friday, kind of?
Yeah, that's basically it, yeah.
Okay.
Conceptually, that's what we're looking at, so.
All right, so any and we'll fix the word order so that it reads better.
Okay.
All right, D3, I think this is just changing the grammar of this. I think everyone agrees. It used to say capacity of the project applied for, leave the hanging preposition, so now it just says proposed capacity of the project. And the rest of the changes in this are just renumbering. So that's all we have there. And then this language here, D1 through 10 and 13, this is changes requested by BG&E and PHI.
That goes to the program design.
Okay, so we'll
Okay.
take this out. Okay, let me see what, I got notes on this, I believe. Page 44. All right, so I think this is all good now. We are removing all of E, and then F, it'll get renumbered, but F basically takes the word pilot out of it. Is that
Right.
everyone else?
Mhm.
Yeah. All right, so this is consensus. I'll just note it. All right, that was page 44. All right, page 48. All right, this was, you see where it says, at the end, it says have applied, and then, they get title to Rex. Well, they actually have to be authorized by the commission in order to have title to the Rex, so I believe this is a consensus.
Yep.
So,
Okay.
I'm gonna mark it as such. Okay, page 51. This is the co-location language. So that's all consensus. Bottom here. Let's see, now, if I'm correct, I think we're taking out and rewriting section or regulation 08. So you're going to see all this here is removed down to this bracket. So everything above that's removed. We're starting with a new A. And then the utility folks have an alternate section of language for B. Staff, I think, proposed much of this, but we are, I think, withdrawing the large portion of what is in the alternate B. So maybe, I think A is now just compliant with the existing language in the law that allows up to 5 megawatts, if I'm correct. So that's why that's the consensus. And then the language for the BG&E and PHI are sort of imposing a requirement to ensure compliance with co-location on the Public Service Commission. And I think staff's concerns about that language is that there really isn't a point in time where staff has access to all of the information needed to do that. think folks have noted that application comes in and we see that it looks like it's co-located, new projects co-located together. We'll look at that to see, hey, is that right or wrong? Is there a problem with that? That's almost like part of our pre-screening process. What we need the utility folks to do is if a project comes in and it's a single project, it might be next to something else that's already been addressed. We do have addresses and that sort of thing, but for the purposes of our process, we would not remove the utilities review of allowing co-location when they're looking at existing projects that already exist. But I'll let and I'll talk further once about the alternative language in B that's now a little different than what you have there once they're done with that.
Yeah, if I may add briefly, so my understanding is that the utilities currently don't have any obligation to verify co-location. So I'm not quite sure what Mr. Vanderheyden was alluding to just now. And on the flip side, today, my understanding is that commission staff reviews the co-location issues. In fact, I think most recently we had a proceeding where there was some dispute about this very issue. We are suggesting language that simply puts those requirements into regulations. It's essentially trying to maintain the status quo. Staff should continue to do what it's doing today in terms of reviewing co-location, and we think that staff is the appropriate entity to do that review, because before a developer applies to the utility, they have to first get approval from staff, and so that the process of reviewing co-location requirements, we think makes sense to do that at the point of the developer applying for the project with the commission.
All right, so this verification process, obviously the applicant would supply staff with the information that the project meets all these various requirements, correct?
So what we get on the application is we get, the name and the SO and all that, capacity, that sort of thing, and we get either a street address or a parcel number. If a project is coming and it's being proposed as a co-located project, we will certainly look at that to make sure that, like, if somebody comes in under the old rules with like an 8 megawatt co-located project on a brownfield, we say, well, your brownfield's 6 megawatts, so you can't do that. That's the level of the screening that we undertake. We do not have access to where all the projects are located on the BG&E's or the other utilities distribution system, so we are sort of expecting that when they go through their co-location process, they're looking at where it's located, and there's some regulation in there that currently requires them to let us know if one of these things is sited within a mile of another one, so they can sort of provide that information to us if we need it. But we are not actually doing the co-location screening from the standpoint of allowing projects in beyond what I just described. So I don't know, maybe no one is screening the co-locations at the utilities, but we had the understanding as their folks were taking a look at where those projects were on their system and noting when there are projects with the meter located on a parcel next to another parcel with an existing project, which we may or may not actually have easy access to.
It's always been my understanding, working on behalf of developers, that staff does do a co-location review, and as you just heard, the commission just considered a couple co-location matters related to staff's review. In my mind, staff already has that ability to do that as part of the SO process. Arguably, this language isn't really necessary because they already do that, and so I think this could just not be adopted, and staff would still do what it does, and the utilities could still do what they've been doing, and there's still that check on co-location through staff's process. And again, it's also an obligation that just exists on developers. So even if staff let one through that didn't comply with the co-location exemptions, that would still be a legal violation of the statute. So there is just that fact as well, that it's an obligation on all developers to comply with these requirements.
Chair, if I may, I actually think that this discussion demonstrates that there is clarity needed. I mean, the commission has heard the utility standpoint and what staff's position and view on it is, and we're clearly not aligned in terms of who has the responsibility of doing it. It certainly, to the utilities, makes sense for staff to do that review, because when the commission gives a project ID number, the utility interprets that as the commission giving its blessing for this project. And there is nothing in the application requirements currently in place for the developer to provide additional information to the utilities so that the utilities can then do this co-location review. I think in terms of process-wise, it doesn't quite make sense for the commission to say, okay, developer, you are approved to proceed with this project, and then later on down the line, the utility is required to make a review that may actually undermine what the commission just decided with respect to that project. I think the review of co-location requirements should be done at the point where the developer is applying to the commission for its blessing.
Well, then you can do that. I mean, you can, for the same reason that I had an issue before with having imposing on the commission obligations in a regulation, that's not going to fly. I mean, you don't put in regulations that the commission shall do certain things. The legislature can do that, but you can put in to the regulations requirements that the applicant has to include, including whether it's complying with the co-location requirements. But having language that says that the commission shall do things in regulation, that's not appropriate. I mean, but you can get to where you need to go if you impose that as a condition in the application. And does that make sense to you, Mr. Bugelmans?
That's exactly it. When staff reviews SO applications, they review a whole host of issues related to compliance. One of those has been co-location.
Right. So if you want to have that specifically referenced in the language, that would be okay. But it's not going to work this way with an obligation on the commission.
If we can find a way to just make clear that this obligation to do the co-location review is not on the utilities, I think we'd be completely fine with that. And, we can certainly get rid of the language that Commissioner Schutzman, you have identified as being inappropriate in your view. I think there just needs to be clarity in terms of who has this obligation. And for the reasons I've stated already, I don't think that it is an appropriate obligation for the utilities. So if the commission is comfortable with simply having the developers, when they apply to the commission, make a representation that they're complying with the co-location requirements, we are completely on board with that.
We don't have a mapping system. We cannot just look at street addresses and figure out what the parcel next over is. If we're going to do this, we're going to have to figure out how. I think we are very happy to continue to perform sort of the intake screening we have, but if we don't see that there was something that had been granted previously, I don't think it's a good idea for the utility to not also have their eye on that and have some responsibility to sort of check that.
And I would just urge the commission to ask the question, where in the statute is this responsibility given to the utilities? For the same reasons I mentioned earlier, if the commission is, again, comfortable with saying to the developers, it's your obligation to comply with these requirements in the statute,
right, and
make that attestation and leave it at that.
Right. If the developer says that they've met the co-location requirements and then they haven't, well, that's on them. And I mean, maybe there are things that we as the commission can do to address that. I mean, you're not going to find everything that is you're not going to be able to go through all applications with a fine-tooth comb. You have to, at some point, rely on the applicant to be.
But, I mean, looking back on the stuff that's provided for CPCN applications, I mean, a lot of this information, you know, I've seen through photographs, drawings, maps, things like that. I mean, it strikes me that it is, the developer should be able to provide sufficient verification of these requirements that would eliminate the need for staff to go out and go look at the place to verify that.
Well, staff request that information. I mean, for instance, brownfields. If a project is trying to co-locate on a brownfield, staff will ask for proof that it's a brownfield.
Okay.
So that's already done. And I suppose, you know, nobody's perfect, and maybe something could slip through the cracks with staff's review, but they do that, and it's, you know, it is meaningful. I mean, you saw some of the result of the review recently, and it, you know, they do it all the time.
So,
sorry.
Yeah, and so to that point, I mean, if you have a question about something, don't you have the ability to say to the developer before you grant anything, you know, you said blah, 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 you know, show me how this is done.
They might not know what's next to them. And I guess maybe just thinking about how this is done now, before we completely remove any obligation for the utility to sort of have some responsibility to check this, I kind of want to talk to our folks that do this internally and say, hey, if the utility is no longer, you know, even obligated to check on this, what do we need from either the utility to sort of check in a project that's proposed against something that's in the queue already or is already installed? That's all. We just sort of have to. I hesitate to say, yeah, we can do that without understanding what exactly it would be the resources needed to sort of perform this kind of check. I guess we had the understanding that through the interconnection process and by, you know, the fact that utilities have infrastructure, you know, systems that allow them to track where their facilities are, that this was already something that would be certainly well within the ability of the utilities to do. We wouldn't necessarily have this information the same way. I will kind of go back and check with our folks and find out, and that might help. But for the purposes of today, I don't know that we need to adopt this language, because I think what it's being proposed to do is not to change anything, but to perhaps change the utility's obligation, saying, well, we have no obligation to do it because the commission shall. So I certainly understand that we wouldn't make the commission obliged to do this in the form of a shall, but perhaps we can leave this out and then adopt these without that language and add this to something we can. It seems like the application process in developing the queue is going to involve something along these lines anyway. So I would prefer that we did not move forward with something that removed any obligation from the utility until we understand exactly what they should be doing.
Chair, if I may, Mr. Vanderhanden has had our proposed language for some time now, right? So this is no surprise. So the suggestion that we further delay the decision on this so that he can gather more information is very concerning and frustrating, because we've been working hard to put forth what our suggestions are, and with the understanding that today we would have at least some closure on some of these issues. On the other hand, if staff is already doing this today, again, we've had recent proceedings where this was the very topic. Staff opposed a particular application based on violation of the co-location rules. I don't understand the suggestion that staff doesn't have the ability to do it. And then the last thing I'll say, at the risk of repeating myself, there is no obligation that the utilities perform this review. So staff's suggestion that, you know, we can proceed and not take away the utility's obligation to perform this view, I simply don't understand, because as things stand today, we do not have such an obligation.
Okay. Well, on on the first point about what we're going to get done today, we're actually not going to finally adopt any regulations today because we've made enough changes, or we're going to need to at least come back in a week or so to do some revised things on that. So the time pressure to get something decided today is not quite as strong as you might think, although I do agree with you that, we can't keep kicking things down kick the can down the road, so to speak. So I guess what I would like to do is, I understand that the utility may not have an obligation to verify this because this is between the developer and staff. So I would suggest that those two entities get together and figure out a process for, having this information supplied by the developer so that staff can do what it needs to do, absent, physically sending somebody out there to go check everything on this list. So
I think if we undertake it, we'll need the assistance of the utilities to tell us what's out there as well, because the new applicants don't necessarily know what's located on the sites they're providing, perhaps, and they may not be able to see what it has been planned for that site but isn't installed yet. So we'll certainly try to come up with a better way to define this process.
all right, let's see what happens out of that, and then because obviously we're going to be revisiting a number of these things in a week or so. So,
All right. So the text at the bottom of 51 and extending to the top of page 52, this was, and we've withdrawn, I think, a portion of this that caused most of the concern. But let me just kind of tee up the issue, and then I'll let I think the solar folks probably have something they have to say here. So there are exceptions to co-location, and the concern is in particular with there's no sort of clear boundary in terms of how large a project could be. And folks have said, well, why is that a problem? Maybe we want really big projects. Well, it can be maybe a problem if you're looking at you're applying for a project and we're looking at it trying to figure out, well, can you build a 25 megawatt community solar facility? I'll give the example of industrial zoning. There was something that said industrial zoning that implied being in a business park or industrial park. That's not there anymore. It just says industrial zoning. So conceivably, if you have a large enough acreage of industrial zoning, you could have a very large community solar facility. And again, no one has proposed anything larger than about 14 to our knowledge, although that in itself is fairly large. So what we're trying to understand here is, should we be, for the purpose of screening projects, looking at something that is much larger than what we have seen? And is there a way to sort of make that very clear to folks when they make application, how large a system could be? So there's nothing in the statute that says it can't be bigger than X. You can't really look at the CPCN rules, or the law. It sort of says you need a CPCN if it's up to a certain size. So this was originally proposed as something to say, hey, well, it's got to be connected to the distribution system, but conceivably, what is the distribution system? And I think from our discussions last week, we understand that that's something at 69 or below 69,000 volts. The regulation actually says generally, so I assume that means for most of the time. We don't have to address this today, but it is an issue that I want to make sure we understand for projects going forward with the permanent program. How large, or should we even be considering this size of an individual or a series of co-located projects if they qualify for one of these exemptions? And rooftops are, you would think that rooftops really can't fit that many, but there are some very large rooftops. Brownfields could get much larger than what we've seen thus far, and then certainly industrial. So the language you see here in the green, and I've struck out the language based on our discussions from last week, because folks are saying, well, we actually might need to connect to more than one distribution feeder, and there were some discussions that the distribution voltage might not be, what you serve a house or a business from, but it could be a sub-transmission line. The issue here is, will we simply accept anything that is accepted by the utilities for interconnection to their distribution system. And is that, how we're going to deal with that? You could potentially allow some very large systems, much larger than what we have seen. So that was the concern. I think we are not trying to make a recommendation to adopt language that would impose any sort of restrictions on us at the moment, but it does appear to be something that maybe it would be easier to accept projects or to sort of have something that gave indications to developers should there be upper limits to what they're proposing to construct. And that's really all I have to say at this point. We're sort of not recommending that the commission adopt something that would restrict the size at the moment, but would like the opportunity to continue that discussion. That's my.
Thank you, Chair. This is another matter that would have been one of the most, if not the most important issues for CCSA if staff hadn't withdrawn the most problematic aspect of what it had proposed, although we still have concerns with what is on the screen right now. I'll avoid some of the specifics because a lot of this has been withdrawn, but again, HB 908 is very specific in terms of what the new co-location requirements are. And then it says the commission shall update its regulations to comply with those requirements. And so what the work group had before it for a very long time was basically just copied and pasted from the statute, consistent with that. So from just a legal standpoint, any addition to that to try to limit what the General Assembly allowed, which is co-location of projects with limited restrictions on preferred sites like brownfields and landfills and those types of sites, anything that imposed another restriction is inconsistent with the statute. What staff has done here is they've removed the single distribution circuit language, which again, that would have been extremely problematic. But they've still added some new language about connected to the electric company's distribution system. In our view, that is not necessary because the definition of a community solar project under the statute says the project needs to be connected to the electric distribution grid serving the state. And so because of that, that's already built into the statute. All these projects need to connect to the electric distribution grid. We don't need to add any additional language to the co-location provisions to accomplish that. It's already just baked into the statute. So we would propose just reverting to the work group's original language before this addition, which I think is everything up until the strike through. And then actually after the strike through, I don't think that's supposed to be green. I know we're going to come back later, so we can talk about that offline, but I think there may be a highlighting issue there. But really what's problematic in our eyes is the language where it says connected to the electric company's distribution system because it's duplicative of what's in the statute in the definition section.
Well, and Mr. Bugelman's, sorry, it's a long day. The statute, does the statute use the language distribution system? What do they use?
It uses connected to the electric distribution grid serving.
Yeah, and that's a problem. If you're using different language, that suggests to me that your intent is to have it be different. So it's not. So that's a problem right away. But I agree, it's duplicative. But if you're going to keep it, you're going to have to change it to distribution grid, not distribution system. It's got to be the same. Otherwise, it's going to raise up an issue of. But I agree. It's not necessary. Does it need to stay?
No, I think the general issue is there a either sort of quantitative or qualitative upper limit that we have to be concerned about?
Right, but we're not talking about that today.
No, we're not.
Okay, so I'm just talking about the language that's there.
I think we're happy to withdraw all of it with the idea that we may want to discuss this issue further to make sure that there aren't any other concerns about it.
Okay, that sounds like a plan.
All right, so connected to the electric company's distribution system is the stuff that comes out.
Correct. Yep.
And then the rest of it is.
The rest can stay, I think.
All right. That was page 51. Page 53 is the next. I believe this is a clarification issue that we have no objections to. 54, so this issue came up. There are two areas that address the MEA and OPC request to receive the data or be able to make data requests directly. This is the one that affects electric companies, and there's this corresponding language on page 59 that addresses the language for the request to subscribe organizations. What are we doing with this?
I think that the commission decided that we're taking this back. I mean, we would love for you just to adopt what we proposed, but my understanding was that you guys asked us to discuss it more in phase two. Yeah.
So phase two, all right, so this was coming out for,
So OPC was going to talk to the developers to see if you could come to some.
Yeah, I guess I was envisioning that we would do it within the work group format.
Yeah.
We'd be happy to talk one-on-one.
Sure.
I will also add, this provision actually relates to data from
That's
electric
true.
companies.
That's right.
So this is a separate provision than what I was talking about, but it's similar.
I understand. Yeah, but
Yeah, you want to try?
major issues.
So to
And
to
you're not-
OPC's surprise, we don't have any hard objection. We think that there's a existing process where OPC can propound data requests upon the utilities, and we're happy to comply with that.
And I've noticed that if you have problems answering things, you're not bashful about letting us know. So.
does that mean we want to leave that in?
So, Your Honor, would we be able in this discussion to consider your offer to have a public utility law judge?
Well, you know,
that would govern
I put that
these?
out there. I mean, if that works to help solve the situation, you know, I'll be glad to talk to the chief judge and figure that out. So, but you know, I'm not saying that that's a requirement. If that helps the process, fine. If you come up with a different way that doesn't require that, that's okay too. So.
Thank you.
All right, so we're still taking that out for discussion, and we'll take out the language on page 59.
That's my understanding.
Okay. All right, so this next issue here is a little more complicated because we have to move some language around. But there's language in here that is saying the electric company is going to provide to the commission the following data no less than 30 days after the end of each calendar quarter. We're talking about the total installed AC capacity community solar energy generating systems that are operating, and B2 is the total number that is associated with eligible customer generators that are engaged in net energy metering. So what we're going to, I think what we had to do here is we addressed that one is talking about total operating community solar, two is talking about total operating eligible customer generators is when you refer to net metering. So there was objections to having the net metering reporting requirement in the community solar subtitle in subtitle 62. So so basically we're going to move the references to net metering to 2050-10, and I have a document to pull up that will kind of show how it lays out. It would have to, it might require an additional regulation for data reporting for this purpose. So I'm gonna, let me just roll down here. There's like a total of 1, 2, and 3, 4, 5, and 6. The language is addressing the operating, the capacity that is in the interconnection queue, and it is for, and then the operational date. So you're trying to figure out, you're saying what's operating now, what's in the queue, and when will that capacity that's in the queue begin operating. And the purpose of having this is so you're sort of tracking each company's total maximum that would fall under that net metering cap. So what you see there in 5 and 6, I think were added later in our discussion, but the other language is just talking about those three things, but for net metering. And I know that I think Potomac Edison has said, if I'm correct, they no longer agree with this, but I thought we had no objections to this language to the extent it was the net metering portion of it was moved to 2050-10. And with that, I'll let the other folks address their issues.
Our understanding was that we had reached consensus on this. I'm not sure what discussion we're having on this
Potomac
topic.
Edison, I thought had raised another issue on that in an email.
Apologize, one more issue for late in the evening. I think much of this goes to the proceeding, Commissioner Suchman, you were referencing on the cap overall. These are things that are meant to track towards that 3,000 megawatt cap. We do agree that they belong in 2050 as opposed to 2062. We did recommend that they go in 2050-09, which is the small generator interconnection report that all the utilities file annually with commission staff. With the commission, and the commission staff compiles that into an annual net metering report. We're suggesting that it should go there if anywhere, but we really think that this needs to be looked at holistically, not just in the context of community solar. So we would appreciate all of these additional reporting requirements to be tabled for that holistic discussion.
Your understanding too, or?
Yeah, we're fine with that. Yeah.
Is that?
So would the idea be to just table this and not adopt any of these regulations, or is that what you've proposed? I'm trying to.
That's our suggestion, yes, from Potomac Edison.
I think it would be useful for the commission to adopt this. I mean, this would be, and I think, again, I also thought there was consensus on this. It was really just a matter of, in what part of COMAR does this go? Does it go in the net metering part of COMAR? Does it go in community solar? From our perspective, it could go anywhere. The important thing was that this information was tracked, goes to the commission to track progress towards the cap. So once we get close, we know that something needs to be done. And I don't think any of the discussion today necessarily means that we need to defer this item.
I'm wondering if it should go in both places. I mean, if the information is important here, but also important in tracking the cap, I mean, it's going to be the same data, so you don't have to find the data again. All you have to do is sort of send it to two different places. So if it's relevant in both places, maybe it should go in both COMAR provisions.
So what I have up on the screen now is the proposed language to go into the net metering rule, and it references this information in the other in 2062, and I have a corresponding edit for 2062 that points back to this. And it also allows the utility to report them together if they
Okay.
choose to do
And would that take care of your concern?
Somewhat. So the utilities file an annual report currently. And then that is compiled again for a report that staff completes to talk about the progress towards the cap. This would be a new report required quarterly that would overlap some of the information. So it's both on the frequency and the duplication. We appreciate if it's one report referenced two places, that's no problem. But we're increasing the frequency of that report today to track progress toward the cap, which we're, I think, approximately about 30 to 35% towards. And there's no indication that we're going to meet that in the near term. We could provide the additional data. We just feel like it's an additional 3 reports per year that are tracking towards something that we're not hitting in the near term.
Well, except that we can't really excuse you if the other utilities are coming closer to hitting the cap. I mean, I'm assuming you just have less opportunity for community solar. Or less interest.
The cap is statewide. I don't believe there's any cap by any utility territory.
Yeah.
Okay.
And that's why it's important for the commission to collect the information and track it, because it's all the utilities together counting towards the cap. It's not utility by utility, which again, that's why we support this tracking language.
So last year we were at 1,100 megawatts statewide. That's last June. I don't know how many new community solar facilities we're about to collect that data again. We may find ourselves adding a few hundred, and that may get us over the halfway point. So, this language is saying, look, we're going to start tracking this quarterly. It's probably, maybe we could wait till next year to do that. And there's language in here that says, the commission can increase the frequency if we get over a certain point. But we don't want to just get surprised and find out, oh, look, we just got it's 2,500. Right.
So, from your standpoint, is the concern the amount of information or how frequently you have to report this?
Yeah, so ours, we have no problem with the information itself. We think from a standpoint of efficiency, it should be in one place, right, and required, once. So that's why what we thought was the proposed edit was to remove items that were appropriate for the net metering regs. It would come out of the community solar regs and be put into the net metering regs. That's where, at least for the X-line utilities, we thought we were. And now this discussion has me confused in terms of what we're actually considering.
And to be clear, just to add on there, that this would be, it's for regulations being adopted to go into effect in January 2025. So it's not a data collection that would start this year.
I mean, the quarterly tracking by next year, I think it's going to be important. Now, we're going to get the information this summer, in probably July, for the net metering report for this year, and that'll kind of show us where we are. We may look, we're probably not going to need this right away. We certainly could relax that, but it should be in there that folks should be prepared to, keep tabs of all of the, especially the net metering data, and not just collect it when staff sends the DR out, in June, but to, at the end of each calendar quarter, be prepared to update that information. I mean, I think there's some flexibility about how it gets posted, but we're going to need that information to make sure we stay ahead of where the statewide cap is. So, I kind of thought we had everybody on board. I'm not familiar with where this would be reported through the interconnection report. And if folks think that's a better way to do it, but I think we do need to have some direction that says you have to be ready to keep tabs on this so we don't run over the statewide maximum. So it's either adopt this language or otherwise say this is unless you have a better way to report it, we want to see this level of timely reporting as something that you're going to be prepared to do by next year.
Well, I guess, one of the questions I have, if you compile the information, filing it twice doesn't strike me as being that big a burden. It's not like you've got to compile it twice.
Yeah. The problem that we have is internally how this works is that there is a department in the company that is responsible for community solar issues.
Okay.
And when they figure out what we are obligated to report and do, they go to the community solar regs for that.
Okay, yeah.
In terms of net metering or interconnection, there's a separate department that does that. So what we were proposing is that to the extent there are net metering reporting obligations, they be placed in the net metering section of COMAR.
Okay.
That's sort of where our emphasis is being placed, not on necessarily compiling the information and reporting the information.
So, for staff's purposes of tracking how close we're getting to the cap, if in fact it gets filed in the net metering thing, don't you get a chance to look at it and make the analysis?
That's once a year, though. I think that it's the net metering annual report is only produced each June. I think what we're asking for.
No, but if we require this to be done quarterly, but done within the context of the net metering regulations, does that solve your problem?
If we have the data, however it's achieved, I don't know that that's.
In the interest of clarity, my understanding of what BG has been requesting, or the Exelon utilities, is just that the reporting requirements related to net metering are put in the net metering part of COMAR.
Right. Mm-hmm.
But that's basically it. It's still, I think, the same requirement. It's just in a different part of COMAR, so people know to look in that part of COMAR. We're fine with that. But in terms of what actually happens, I don't think there's any difference.
Yeah.
So.
Right. Okay.
So I think there's consensus here. It's just Potomac Edison. It seems like they don't support this concept at all. So I think that's where the dispute is.
To be clear, I think we agree with everything except for the frequency at this point. We don't have any objection to providing the data. We obviously keep track of everything in our own internal systems, and we absolutely can provide the data quarterly. We're just saying if the whole purpose of this is to track towards the cap, we don't see the urgency to add those additional reports, but it is not an extreme amount of burden for us to do some. We can do it. We're just offering that, is it 3 reports that are needed to be filed every year?
So, and right now, this is reported just annually?
We sent data requests out to obtain the information for the net metering report typically in June of each year. So we don't have access to this more than that frequently.
Okay, so you're suggesting instead of getting this once a year, you'd get it 4 times a year?
Yes.
Does it make any difference to you if it's instead of 4 times, twice? Or does the frequency of the report not matter? So.
Yeah, we're okay with doing it quarterly. Our concern is let's not have this same responsibility in different places.
No, I understand.
Yeah.
So, all right, so let's do it quarterly. We'll put it in the net metering regulations, but you'll have access to the information on a quarterly basis, so you'll be able to make your analysis, and you'll see it too. So, all right.
All right. So regarding the language, are we sort of folks okay with this, and we're going to retain it then, because that's what this does?
We're fine with that language, Phil.
So, and this is the net metering version of this, and we're going to add this to 2050, and then what we've got as edited will be this corresponding version of this, but in the 2062, where it's only addressing the community solar capacities and that sort of thing, which is what we talked about last week.
Okay.
All right.
All right.
So, let me come back to my main document. All right, I believe we're on page 55 or 56.
This is design. We can skip this.
Okay. And 59 gets back to this is the original language that OPC addressed. And so I believe we're taking that out for now. All right, I believe that is the last of the edits to this document.
Okay.
So we are not changing anything. I'm sorry. Well, there's changes in 05, but nothing not consensus. It's just housekeeping changes in chapter 5.
Okay, so what I need you to do is take the guidance we've given you and then the collaboration that needs to be done, and then get together, and then at an administrative meeting, either next week or the week after, we'll, adopt the regulations once we've got all this worked out. So,
will do.
Anything else today?
Nope.
All right. Thank you very much.
Thank you.
Thank you.
If I could just get the net metering flipped real quick. So, got this. John,
Now we just have to hope that what
Send
you
it around.
said the other day about 95
Save it.
South.
Email it out to
Actually,
her.
I watched it, so we had all the traffic coming up.
Yeah.
There
Well,
was
maybe they
nothing-
fixed it. I mean, apparently it was like
He actually wants to watch you send it.
They kept talking about they had to do like emergency repairs to the bridge. So I don't know what happened.
Well, hopefully, it's Wednesday.
Yeah.
So whatever.
I mean,
they
I didn't
have
hear
to
about it
do-
this morning when I was driving up.
did not?
No.
So that's what I'm.
So hopefully you're.
So I'm hoping that all the Orioles fans are